seek my lord's indulgence to mention 3 matters for listing tomorrow. It has to get listed before the appropriate bench, lordship. These are APSC matters. I'm praying for listing tomorrow.
That is not to be before me.
Yes, lordship.
There is another bench. Make a mention there because APSC matter.
Lordship being the senior judge.
No, you inform the bench that we cannot take up.
Lord, I may be permitted to move a similar, my lord, unlisted matter as of the yesterday, one of the advocate from here, my lord, if possible, my lord, in the first half or after the motion. Then she can avail the today's exam also perhaps, my lord.
Okay.
With your lordship, lordship, pray for listing of a motion matter tomorrow, your lordship.
May I please, your lordship? Lordship, I taking consent from other side. I beg to mention item number 14, my lord.
Item number
Adjournment for the day, my lord.
1-4.
1-4, my. My senior ICK sir is not well, my lord.
You are for petitioner?
Yes, ma'am.
Okay. On the prayer of Mr. B. Bora, learned counsel praying for a petitioner. The case is passed over for the day. Consent has been taken.
Taken, ma'am.
Okay.
After vacation, my lord, madam.
Okay, then sought for by Mr. B. Bora, learned counsel preparing for a petition. Place the case on a date immediately after the ensuing long vacation.
May I please,
Consent.
sir. No, sir.
Yes.
26 and 30, lordship may not like to take up
Oh.
the matter.
26. Place the case before any other events without me.
26
26
and 30, my lord. Okay.
May I please, your lordship? I'm praying for. May I please, your lordship? I'm praying for the inclusion of WPC number 2251 of 2025, your lordship. It is very urgent matter, your lordship. It was to be listed after 4 weeks, but then 14 weeks has already been passed. It is a case where the petitioner has been forced to get superannuated 4 years prior to his date of
Next week,
retirement.
next week.
Obligation.
May it please the lordship. Lordship, I'd like to mention item number 15 to 19 for adjournment, lordship.
15 to 19?
Yes, lordship. I've already informed the other side.
Okay. You are petitioners?
Yes, lordship. In all the cases, we are the petitioner.
In these cases?
Yes,
15, 16, 17,
18 and 19.
and 19.
Yes, lordship. There is interim in 15, 16 and 17, lordship, that may be
Okay.
extended.
Miss N. Begum,
Yes.
learned counsel appearing for the petitioner. When do you want?
Lordship, any convenient date?
After vacation?
Lordship, after a week, maybe.
Okay, we'll put after a week. These cases after a week on a date to expedite office. It is submitted that consent has been taken from the learned counsel for the other sides to make the prayer. The interim orders wherever passed, shall continue till the next date of this.
May I please, your lordship, prayer for listing, WBC number 290925.
For
Of-
admission,
for
Admission?
For
admission,
yes,
hearing or admission?
admission.
Okay, give it to the court master.
May it please, your lordship. Lordship, I beg to mention item number 31 of today's daily list.
Yes,
Lordship, we have already informed the other side and also we.
you are for the petitioner?
Yes, your lordship. I appear on behalf of Mr. S.P. Sharma.
Mr.
N. Sharma.
N. Sharma, learned counsel. Appearing for Mr. S.P. Sharma, learned counsel for the petitioner has made the prayer for adjournment. Its mentioned memo has also been circulated to that effect yesterday. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. The prayer is allowed. Raise the case after
2 weeks, your lordship.
2 weeks.
Lordship, there's an interim interim
By
order.
the office, interim order salable, if any, shall continue till the next date of listing.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention for listing up of a matter, Lordship. Matter relating to non-payment of pension. Lordship may kindly list the matter any day next week.
Lordship, I beg to mention listing of a writ petition for admission next week.
Okay.
May I please, your lordship? My lord, may I pray for listing on motion matter, my lord, tomorrow, my lord.
What is the subject matter?
Subject matter, my lord, compassionate appointment, my lord, direction of this court. was passed by-
Competition, it can wait Monday.
My lord, 13th of 8 August, my lord, notification has been given that last date of 15, my lord, we have to apply and mention that whether we have challenged notification dated 18/9/2024 or not, my lord.
14, it will be listed on 14, 15. 15, 15.
May I pray for all 30
15,
minutes?
15. Already many matters listed. 15.
Lordship, item number 12.
12. Yes,
Kindly pass over the matter, my lord.
you are Miss
B. Sharma.
B. Sharma. What a petitioner. What a petitioner. Okay, on the prayer of Miss B. Sharma, learned counsel, appearing for the petitioner on the case is passed over for the case. You have informed the other sides.
Yep.
Have you informed the other sides?
No, my lord.
SC Finance, Rima Hassaf. If they object, oh, this is in the mediation list. Why you are? You wait. Mediation is according to you. That's a motion to law. Okay.
For withdrawal, item number 32.
Yes, Mr. Padgini.
Always a compliant.
Okay. Mr. K.R. Padgiri, Land Counsel for the petitioner, has submitted that the direction made in the order dated 25/9/2024 passed in contempt case.
My lord.
Passed in contempt case C number 270/2022 has already been complied with, and therefore, the petition doesn't want to pursue the instant petition. So, in view of the above submission made by Mr. Padgiri, Land Counsel for the petitioner, this contempt petition is closed.
Compliant.
For referral to mediation. Item number 2.
What is the subject matter?
The family pension, Your Honor, for
Okay.
disabled child,
Or?
disabled child.
Disabled
Disabled daughter, yeah, disabled daughter.
Okay. Mr.
J. Mohanto. I'm the-
J. Mohan, Land Counsel for the petitioner. Who is for the respondents?
I am the respondent number 7, Lord.
7. Agriculture? Mr.
A. Bharadwaj
A. Bharadwaj.
on behalf of Arbora.
Arbora, Miss Arbora. Standing Counsel, Agriculture Department for the respondent number 145. Yes, Miss R.R. Soikia, Land Counsel. S.K. Mehdi, Standing Counsel, Accountant General for the respondent number 3. Any finance? Any finance? Yes, Mr. Barbujari. Come here. R. Barbujari. Standing Counsel Finance Department for the respondent number 1 and 6. 2 and 6. And Mr.
I am R. Islam.
M.R. Islam, Learned
But
Counsel for
only
the
R.
respondent number
R. Islam.
R. Islam.
Okay.
Learned Counsel for the respondent number 7 are present. Most of the subject matter of this petition is a claim for family pension on the ground that the petitioner is a disabled, physically disabled child of the pensioner.
Yes.
Okay. Again, लिख दीजिए. First date is 15/9. Mediation 15/9.
Lordship, any other date, Lordship? 15, I have some delay, Lordship.
16/9.
18,
18.
it's an old lady, Lordship. I think from the.
Let her appear virtually
Lordship.
on 15/9.
Not 15, and I have some difficulty.
16/9.
Okay, Lordship.
Virtually let her
Lordship.
appear.
Item 3.
Yes, Miss Gayan.
Madam, that matters pertaining to the non-payment of family pension, my love, they have received some amount, my love. Some amount yet to be received, my love.
Let us have.
Yes, my love.
Who is S. Bora? S. Bora should be there.
Yes,
Yes, S. Bora.
yes, yes.
Petitioner.
This matter relating to
Some amount has been received.
amount has been only the leave encashment amount to be.
Yes.
Let me, can be sorted out in the,
Unlike it
Mediation.
to be in the mediation.
it can be sorted out.
Yes, ma'am.
Leave encashment.
Only leave encashment party.
If it is undisputed, it can be sorted out. Let us
Yes,
have
sir.
an report. As Bora petitioner, A. Gayan, standing, Central Government Council for all the respondents.
ma'am.
Okay. the council for the parties have submitted that the out of the retirement benefits,
Yes.
the petitioner is eligible to receive, only the leave encashment benefit
Yes.
has not yet been disbursed.
Yes.
Full stop. 15(9),
15.
15(9).
Lordship.
Yes.
Virtually you can do also.
Lordship.
Yes.
Yes, sir. Mr. R. Islam,
No, man, SH Mahmood.
huh?
SH Mahmood.
Non-regularization.
And
Non-regularized.
pensionary benefits, man. Our services have been regularized, man.
Also regularized.
No, Lordship, if Lordship may kindly turn over to Annexure 2, page 11. It was subject to approval and subsequently I have received instruction. It was cancelled way back in 2000, within 2 months thereafter, from the date of issuance of that order. Lordship, second, by this order may stand cancelled if the government of Assam in particular does not accord necessary approval for this purpose.
Page.
Page 11.
But you allowed him to continue till 2021.
Yes,
Huh?
it's there, Lordship.
Let it be once have an effect. Mr.
SH Mahmood.
S.
H Mahmood.
Mahmood,
Yes, sir.
petitioner. Mr. B. Choudhury, Land Standing Council, Public Works Department,
And BTC, Lordship.
and BTC for all the respondents. For the respondent number 1 to 3. R.K. Taluja, Standing Council, Accountant General. For the respondent number 5. S. Borua, General Junior Government Advocate Assam for the respondent number 4. Full stop. The subject matter of claim of this petition is disbursement of pensionary benefits to the petitioner. I can give you. 15(9). Give information to your client.
Yes,
At least some competent and responsible officer should be there.
yes, ma'am.
It will be in the order, but still.
May I please look, sir?
Yes.
Lordship, matter pertains to non-payment of service and some post-death benefits payable to the.
Post-retirement benefits.
Yes, yes. Not retirement, she died, mother died while the petitioner was a minor child. At
Okay.
that period.
PNB. Who is there? Respondent?
Mr. A. Ganguly.
Would you inform Mr. Ganguly?
Yes.
Okay, Mr. S.B. Prasad,
That's good.
Council for the petitioner, is present also. The petition by this petition has sought for arrear retirement dues of his deceased mother. Listed so and so. I can लिख दियो Mr. A. Ganguly, पर लिख दियो learned counsel appears for the respondent, Punjab National Bank authorities. He informed Mr. Ganguly, 15-9.
Number 6.
Provincial number. Yes, Mr. Chaudhary.
Yes, my lord. Here, my lord,
Yes.
instance case petitioner was appointed, my lord, in the year 1991, my lord.
What is the subject matter?
Subject matter is non-payment of pensionary benefit, non-payment of the pension to the petitioner. And my lord, till today, they have not, my lord, finalized my pension.
NNB Chaudhary. We put it on mediation. NNB Chaudhary learned counsel for the petitioner. Irrigation, and standing counsel, irrigation department, 1, 2, 3. Finance, A. Soliha, standing counsel, finance, 4. A. Chakraborty, junior government advocate Assam for the respondent number 5. C. Borua, standing counsel, accountant general Assam for the respondent number 6. The subject matter of claim in this petition is release of regular pension and other retirement benefits. Post 15-9.
16, man.
16.
Yes.
16. 16. Okay. See what had SK में थी लिखी थी. Standing counsel, accountant general.
Item 7 and 8.
Yes,
Right.
Mr. Uddin.
Oh, my lord.
What is the claim?
things- My
What
lord,
is the
by
claim?
impin order, page 43, my lord, they rejected, my lord, I am not entitled for any pension, any benefit.
Pension.
Yes, my lord. Pension and, my lord, arrear salary, my lord. So.
You are serving where?
Oh, my lord, I was serving.
Medical and health officer.
Yes, my lord, Karimganj. And I continue to serve my lord, since 1998 to October 2003.
Okay, let us have an effort thereafter we'll decide. Ziuddin,
Yes.
petitioner. Or D. Upamanyu,
For respondent 1, 2, and 3.
standing counsel, Health and Family Welfare Department, 1, 2, and 3. Mr. D. Bharasaiji, standing counsel, accountant general, Assam, for the respondent number 4. Petitioner's claim in this petition is what is your claim otherwise? Retirement benefits.
Yes, as well as arrear salary.
Retirement benefits and area salaries. Post on. Okay, listed 15-9.
Yes, Lordship. Lordship, the next matter is contempt petition, Lordship. That speaking order has been passed, Lordship, for compliance of the order, Lordship. So they have challenged in this writ petition. So the contempt can be closed, Lordship. Item 8, Lordship. Because already they have challenged the
Contempt. Okay, Ziuddin, petitioner. You appear for?
Lordship, the health department, Lordship.
Okay. And Mr. D. Upamanyu, standing counsel, Health and Family Welfare Department,
For
Has-
both the contempt.
has appeared for the two respondents, both the respondents, full stop. In view of challenge made. Made
Order dated 4/1/2022,
4/1/2022. In the,
page 43.
in a writ petition, WPC number 3991/2022. This contempt petition is closed.
Highly obliged, Lordship.
Item number 9.
Yes, Mr. Padgiri.
This may not settle by the
Why?
mediation because my lord, law point involved in this case, my lord.
Let us see your serving as constable.
I left it.
While
Husband
husband
of the petitioner discharged from service, my lord.
And being an application for voluntary retirement before the concern of the newspaper. Ultimately died on so leaving a petition for Your father served for how many?
Father, my lord, my lord,
How
my
long?
father, husband,
How long? Oh, your husband?
husband, my lord.
Huh.
But the respondent.
Let us have it. If the good sense prevailed upon the respondents, they may grant it mediation. Yesterday also I have seen many complex matters have been settled. Supreme Court has reported. K.R.
stand-
Padgiri,
My lord.
they may have it
My lord.
lenient view.
My lord.
Let us have. J.K. Goswami, addition senior government advocate for the respondent number 1, 2, 3, 5, 6.
It's till
Uh,
6, 1
uh,
to 6.
R.K. Ravibhar, Accountant General Assam. 4. H. Oliha, Finance. 7. Full stop. লিখি দিব again, নালাগে ইয়াতে লিখিব. And the claim of the petitioner is for release of monthly compassionate family pension as the petitioner's husband, a constable in Assam ASRF battalion, died on 1/3/2021. 15/9.
My lord. Oblige.
B.J. Ghosh.
May I please, Your Lordship?
Yes, Mr. Sheikh.
Well, this matter may not be referred before the mediation.
Why?
My lord, the similar issues is pending before the Honorable Supreme Court, my lord. Matters pertaining, my lord, pensionary benefits of the works of employees, my lord.
Works as section assistant after
Right.
attending he retired from service after advisor.
My lord, before
Okay,
the
if it
Honorable
comes back, comes back. He's safe. If it comes back, okay. No harm. No harm.
My lord,
No
civil,
harm is going to be caused. Finance.
yes, sir.
Solia.
PWD,
PWD. Miss M. Das, Standing Council, PWD 1. Solia, Finance Department 2. Accountant General. B. Sharma, Standing Council, Accountant General. Assam 3. PWD 1. 4. S. Borua 5. Junior Government Advocate, huh? PWD আকৌ 6 and 7. PWD তাৰমানে 1, 4, 6 and 7. Okay. Superannuation benefit,
my lord, pensionary benefits, my lord.
pensionary benefit.
Works as employees.
As a workforce employee who has rendered 27 years of service
Yes, my lord.
as a work charge employee under the respondent Public Works Department.
Right.
15/9.
Public.
Power distribution.
Yes.
Yes, what is the claim?
Well, here the thing is that the petitioner is retired now, but he was getting,
Your claim is limited to what?
yes, lesser salary than the junior, my lord. So to,
APTCL.
we say last time also, I don't know. There's an order, my lord, to, they have not responded till date by filing any affidavit.
APTCL Standing Council. Can you call? It is a retirement benefit, so at least we can make an effort. You need salary at a higher scale.
In higher scale.
Mrs. Cholia, can you take the trouble of informing somebody? Okay, B. Sinha likhibo petitioner. That's my understanding of Assam Power Distribution Company Limited, APDCL. For the respondent number 1, 2, and 3, and Mr. A. Choliha, Standing Council Finance Department for the respondent number 4. Full stop. The petitioner's claim in this writ petition is fixation of his salary. We put it on mediation, let us have it. After it comes back, comes back. Mr. Shalia, you are for port. PN Goswami and we are standing off the application 1 to 3. Fixation of his salary at a higher scale and other retirement benefits. 15.9. You tell somebody from the APDCL to be present. Huh? Oh. After the degree owner. Regularization of service, 26 years of
Service.
service rendered as a chokidar instructor. Liaison Dima Hasa. Basically Dima Hasa.
Yes, sir.
Yes, madam. Dima Hasa. Then you call your official for mediation. You are a main party. And so, is it not? Okay. Miss Ting Liang. Okay, Mr. There is no good. Morning, huh? D. Sharma. D. Sharma. Petition. Ting Liang, the Standing Council, Demands of Autonomous Council, 2, 3, 4. A. Shalia Finance, 5. Like B. Sharma, Accountant General, Assam, 6. The petitioner's claim is regularization of our service for rendering 26 years as master roll worker. J.K. Goswami, additional senior government advocate, Assam, respond number 1. Hill areas developed 59. 59, madam. You appear before the mediator, right? Mediation sir. Okay.
That time, last occasion, I had handed over a copy of that judgment, my lord, which says the
Oh, there is another one, I think. Along with that, maybe in the other one. Which item?
item 20.
20 to sound. Two zero. Muhimuddin. ইয়াতে C বরাজে লেখা আছে। I don't know. Yes, Mr. Bhattacharya. Item 20 is yours. Okay, let us get the facts right, right? I don't know. Two petitioners.
Two petitioners.
Okay, let me please have a seat. I'll go through it. Then I will understand. Irrigation, finance, administrative account, chief engineer. That's Sansita Roy. They have 20 years and more, and this 6 years deduction. Now that is under review. That is under review.
No.
Huh? Mr. Soliha, which one is under review?
There is no review though.
No, there is one review petition moved before this court by Mr. R. Borbuzari. But originated from Sansita Roy only.
Yes, Lordship, but that six-year deduction period is holding, start holding.
So this deduction should go.
Go, Lordship. This is good. This is good.
And our section. It's make no difference because only minimum count is 25 does that they still have. And if it's insurance that is added, it's make no difference, only the difference come into the gratuity.
Maybe whatever they will
That-
try to examine. That is
Not-
the directions by the coordinate benches.
Yes. They will examine.
Mr. Bhattacharya, your case first, then Mr. Mukherjee's case. Facts are the next paragraphs will be same. Common. Okay. Third, Mr. C. Bhattacharya, learned counsel for the petitioners. Mr. N. Upadhyay, learned standing counsel, Irrigation Department for the respondent number 1, 4, and 5.
1, 4, and 5 also.
Mr. A. Choliha, learned standing counsel, Finance Department for the respondent number 2. Ms. M. Bhattacharya, learned additional senior government advocate, Assam for the respondent number 3. And Mr. B. Chakraborty, learned standing counsel
Also, Mr. Is getting item number 1.
of C. Bhattacharya in item number 20. Okay, Mr. B. Chakraborty, learned standing counsel, Accountant General A&E, Assam for the respondent number 6. Heard. The two petitioners have stated that they were initially engaged as casual master role workers in the establishment of the erstwhile executive engineer Thuburi division within bracket irrigation, Gauripur on 1/10/1984 and 1/3/1980 respectively. Full stop. Establishment irrigation, Gauripur shall likibo, presently, O/O, the executive engineer, Gauripur - Bilaki Para, West Division, Irrigation, Gauripur. There are 2, 3 just. The petitioners have stated that pursuant to a government letter number so and so, dated 3/10/2005 and Finance Department's letter number so and so dated 22/8/2005, the respondent number 5 provide an office order dated 6/10/2005 within bracket annexer 1. Annexer 1.
I have put it as
A,
annexer
A.
A.
Regularize the services of the petitioners in the same office. WEF 2207/2005. Full stop. Para. The subsequently, the petition number 1 and the petition number 2 retired from service on 30/09/2017 and 31/8/2017 respectively, on reaching the age of superannuation from the office of the respondent number 5. Full stop. The petitioners have stated that the petition number 1 retired on superannuation after rendering 33 years of service, and out of the 33 years of service, 12 years were rendered as a regular helper, and the remaining period was casual stroke master or worker. Full stop. Insofar as the petition number 2 is concerned, the petition number 2 stated that he rendered 7 years and 6 months of service, and out of the said period, 12 years were rendered as a regular helper. Full stop. Para. When after retirement on superannuation, the petitioners submitted their pension papers to the respondent number. When the petitioners' pension papers were forwarded to the respondent number 6, pension payment orders were issued in favor of the petitioners. Full stop. In the PPO of the petition number 1, the pension figure was shown as 11,720, and the amount of gratuity was shown as 3,32,127. It was recorded that the gross service of the petition number 1 was 33 years, and his net qualifying service was shown as 27 years, with his last pay as rupees 23,430. Full stop. With the above figures, the net pension amount payable to the petitioner number 1 has been worked out as rupees 11,720. WEF 110/2017 in the PPO. Full stop. The respondent authorities had also recovered an amount of rupees 2,24,030 as excess drawal of pension from the area pensions of rupees. What is recovered?
24,000.
Okay. As area pensions from the area pension amount of rupees 2,24,558. WEF 110/2017 to 28/2019. This is petition number 1, para 6. Full stop. Para. In the pension payment order issued to the respondent number, petition number 2, the pension amount drawable was shown as rupees 11,720, and the amount of gratuity was shown as 3,87,482. Full stop. The petition number 2's gross service period was shown as 37 years, and net qualifying service for the purpose of calculating pension was shown as 31 years, 6 months. Full stop. The last pay of the petition number 2 was shown as 23,430. Full stop. With the above figures, comma, the net pension amount payable to the petition number 2 has been worked out at rupees 11,720 WEF 19/2017. Full stop. The respondent authority has also recovered an amount of rupees 25,050 as excess royal of pension from the arrear pension amount of rupees 2,37,464 WEF 19/2017 to 28/2019. Those purposes. Para. It is the case of the petitioner that while an office memorandum number para 7 dated 20/05/2009 of the Pension and Public Grievances Department, comma, Government of Assam, comma, it was decided to exclude initial period of 6 years from the past services rendered by master role workers for the purpose of working out pension and death retirement gratuity. Full stop. The said office memorandum dated 20/05/2009 what was put to challenge in a batch of writ petitions, including WPC number 1089/2015 within bracket Sanjita Roy versus State of Assam and others. Bracket close. Full stop. It was contended that the decision to exclude initial period of 6 years service as master or worker were 20 years of quota requirement of 20 years of service as a prerequisite for being eligible for pension was arbitrary. Full stop. Where the batch of writ petitions, including WBC number 1089/2015, comma, was disposed of by a common judgment and order dated 4/12/2018.
Not 29, but 29, 30. 29.
The coordinate bench, after taking into consideration that to be eligible for pension, the casual master role workers whose services were regularized, should complete 20 years of total service, has observed that the deduction of 6 years, initial period of 6 years, is unreasonable and unfair. It has been held that it would be unfair and unreasonable to deny a master role worker who has admittedly completed 20 years of continuous service, continuous service. Full stop. The repetitions were disposed of directly. The respondent authorities to determine the continuous length of service of the petitioners who were master role workers, and has further observed that if such service period meets the benchmark of 20 years without any deduction, the benefit of pension should be made available to them. Full stop. So, yeah, I think that another order following from this regarding 6 months, I think that is the subject matter of review. 6 months should be 19 years, 6 months should be worked out at 20. I think that is that may be a subject matter of review.
The relaxation part was.
Relaxation part, some 6 months.
Yes, yes.
If I am not wrong, somebody pointed it out. Okay. But it has been submitted by at the bar. That when the judgment and order common judgment and order dated 4/12/2018 was challenged before the division bench in writ appeal number 18/2021. Within bracket, Binapani Das versus State of Assam and others. The view of the learned single judge was upheld by the division bench in its judgment and order dated 26/2/2021. Correct? Post on. Para. After the division bench judgments upholding the common judgment and order dated so and so. Common, the position that has been crystallized is there no deduction, no exclusion or deduction of initial 6 years of initial service from the total services rendered by an incumbent as a master role workers while calculating the period of service towards eligibility for grant of pension. No deduction is to be made, huh? Is to be made. It has been held in Sanjita Roy Supra that once the benefit has been granted by way of a judgment, the same cannot be curtailed to deny the benefit to other similarly situated persons when the original judgment has not restricted such benefit. By holding that the orders, by reiterating the settled principle that the orders of courts are always retrospective in nature, unless it is specifically made prospective in the order itself. First off, the relevant excerpts from the which is division bench judgment?
That's it. May I pass? That's it.
While upholding the judgment of a single judge, judgment and common judgment and order of a single judge in Sanjita Roy Supra, the division bench, as in Vinapani Das, has observed as under para 9 of the division bench judgment. What is this office memorandum 2010?
Lordship, Annexure E, Lordship, page 60, last para, Lordship. May I read, Lordship? Further, the government in pension and public grievance department is aware of settlement of pension cases of regular master rule prior to issuance of this department, so that if pension cases of such regular master rule were prior to issuance of the said memorandum dated 25/2009 have been finalized by the Accountant General. The Accountant General may enlighten about the procedure adopted in as regards pensionary benefits to regularize workers worker. The master rule period of regularized workers should also be counted for the purpose of allowing him her pensionary benefits.
It is pertinent to mention that the pension in an office memorandum number so and so page 60 dated 31/7/2010, comma, the Pension and Public Grievances Department, Government of Assam, had clarified that the master role in case of regularized master role workers appointed against sanctioned vacant posts clarified that as regards pensionary benefits to regularized confusing. The reverting back to the facts of the case in hand, comma, it is stated that provide letters, comma, dated, both dated 6/4/2022, comma, the respondent number 5 had forwarded the applications of the petitioner to the respondent number 6. With a request to sanction revised date cum retirement gratuity by taking into account that while issuing the pension payment orders earlier to the petitioners, the initial 6 years period of masteral service was deducted as non-qualifying service. Full stop. Where the petitioners have approached this court by the instant writ petition, we take grievance that despite the cases, despite their cases were forwarded as far back as on 6/4/2022, fresh pension payment orders have not been issued to the petitioner after excluding, after revising, after recalculating the total period of qualifying service for the purpose of pension, after deducting, after including the initial period, 6 years period of service rendered by the petitioners as master role worker. Full stop.
Section also for this instruction also.
Wrong.
Pension amount is not, will not increase, only the gratuity.
No.
Because we calculate 25 years, whatever 20 years service.
Okay.
That is the instruction.
Mr. Chakravarti line is telling us. Accountant General Assam. Having for the respondent number 6 has submitted on the basis of written instructions received by him, that an employee of the Assam government requires minimum 25 years as qualifying service to receive the full quantum of monthly pension. Full stop. He has submitted that in case of the petition number 1, the net qualifying service after deduction of initial 6 years of service was 27 years. Whereas for the petition number 2, the net qualifying service after deduction of initial 6 years of service was 31 years, 6 months. According to Mr. Chakravarti, both the petitioners' qualifying service was above the benchmark of 25 years. Hence, they have already been allowed full pension at 50% of the last basic pay. This logic is not correct.
Later part is not still. That's three lines of that paragraph.
Post op.
Say that because the OEM after that was this 2019 issued by the department that petition and there's been mentioned.
But that has been made redundant now. What the logic? That has been made redundant. They don't understand the basic law or what?
I told them.
According to him, only difference would be in the calculation of the gratuity amounts for the petitioners. Full stop. Be that as it may. Full stop. As the division bench has already clarified that the direction and observations and the directions made in the judgment in Sanjita Roy is retrospective in nature. And the petitioners and the two petitioners' pension amount and other retirement benefits like gratuity have been worked out by excluding initial period of 6 years of service they had rendered as master role worker, the respondent authorities, including the respondent number 6, have to redo the exercise of calculation of the pension amount and other retirement benefits like gratuity. In the cases of the petitioners, after excluding the initial period of 6 years, the petitioners had rendered as master role worker. If after redoing the exercise, it is found that the amount of pension and other retirement benefits, including gratuity, are to be payable at an enhanced rate after taking into consideration the petitioner's entire period of service as qualifying service. In view of the judgment and order dated passed in Sanjita Roy Supra and Vinapani Das Supra, that the same shall be released to them without any further delay, as expeditiously as possible, but within an outer limit of 3 months from the date of receipt of a certified copy of this order. Also, B.J. Mukherjee is still there. ওপৰখিনি সব একে ফিগাৰটো খালি ওপৰখিনি B.J. Mukherjee petitioner এইটো 3974 দুজন petitioner আছে B.J. Mukherjee petitioner and Upadhyay
For one lordship.
standing as irrigation 1, Esoliha finance 2,
Madam for 3
M. Borasaidi, Additional Senior Government Advocate, Assam. 3. Mr. B. Sharma, Standing Counsel Accountant General, Assam, A&E, Assam. That's point number 4. Post. The case of the petitioner in brief is that the petitioner was engaged as a casual master road helper in the Dhubri division of the irrigation department by an office order dated 6/10/2005, issued under the hand of the executive engineer is not there. Executive engineer, irrigation, Dhubri division irrigation department. Post op. Pursuant to a government letter number, dated 3/10/2005, and the finance department's letter number 3,000, dated 22/8/2005, the service of the petitioner aimed to be regularized by an office order dated 6/10/2005 by issued under the hand of the executive engineer Dhubri division irrigation department, Annexer 1. With effect from 22/07/2007 in the scale of pay mentioned therein.
2005.
Huh?
2207.
2005. Post op. The petitioner stated that he rendered continuous unblemished service for a period of about 28 years. Post op. The petitioner further stated that he retired from service on 31/3/2018 on reaching the age of superannuation. Post op. Out of his 28 years of service, the petitioner had rendered service as a master role casual employee for a period of 16 years continuously, and the remaining periods since 22/07/2005 till 31/3/2018 was a regular service, was service as a regular employee. Para. After his retirement on superannuation, the papers were forwarded to the office of the respondent number 4 by his departmental authorities for calculation of the pension and other retirement benefits. Full stop. The petitioner had received, a petitioner was received of the wage of pension payment order.
That is not next.
Not there. Not there.
Not here.
Okay. Received the pension payment order in due course. Full stop. In the pension payment order, the petitioner, by the pension payment order, the petitioner was granted an amount of rupees 10,310 as pension, monthly pension amount. So according to the petitioner, the monthly pension amount ought to have been worked out at rupees 11,681. The basis of the petitioner's claim is that while working out the pension amount and other retirement benefits, the respondent authorities including the respondent number 4, comma, had excluded the initial period of 6 years, the petitioner had rendered service as master role employee. Full stop. As the petitioner has further stated that as such reduction of initial period of 6 years service has been held to be bad and arbitrary by the judgment rendered by this court in Sanjita Roy by this court, comma, the petitioner made an application before the respondent number 4 in 2023 to make correct assessment of his pension amount on the basis of his last pay and treating the entire service period of the petitioner and entire service period of 22 years and 4 months rendered by the petitioner since his appointment as such assessment, comma, sought for by the petitioner have not been made in a subsequent period. The petitioner is before this court by the instant writ petition. Other things are same. Come on. 3 months walk out.
Lots of law.
Huh? Okay, you go. Keep it like this.
I didn't want. Exactly the same order, my lord, that was passed yesterday.
You got the copy yesterday?
I have an next, my lord, at page 72, my lord.
Lordship, in this case, I am seeking one further indulgence from this court.
We'll modify if
No,
required.
not necessary, not the negative indulgence, that we have 65 and more candidates of who could not submit that COP. And if we get some handle from this court that we have the liberty to verify, scrutinize those and to take a decision, we will allow it. This is the latest instruction I have received today. I pray that some sorts of observation may be made.
On the basis of my submission, which is also reflected yesterday, that so many
Ah.
candidates have been
Fine,
deprived.
mention the rejection list.
Lodged.
I have observed somewhere.
Lodged.
Yes, Lordship.
Mr. Soikia's last permission.
Yes.
A number of other candidates have been deprived from appearing in the so on the same ground. Para 5,
Yes.
Verified.
page 74.
Lodged.
We
In
put
that,
it.
in that regard, liberty may be granted to them to take their own decision with regard to others.
Let's observe so far, Mr. Doctor will record that.
Lordship.
Has received instruction, we can observe that.
Lordship.
Then this is APSC authorities, is at liberty.
They would
That is up to you.
Yes.
That would suffice.
Because this salage is only confined to the
Yes.
petitioner.
APSC authorities receiving numbers of applications that may be recorded and we may be granted liberty.
Okay.
And may be subject to the outcome of this petition. These are, yesterday one is pending.
He has appeared.
Yes.
Yes, he has appeared.
Okay. Other things are same.
Everything
I
same.
see.
Everything is same.
Only difference is that.
Okay. A page 73 order to us, huh? Pate. PJ Soikia, Senior Counsel, estate by KZ Soikia. And Mr. PP Doctor, Standing Counsel, APSC. Estate by Ms. P. Sharma. Para 2 to same. Para 3 sim. Para 4 sim. Para 5 sim. Para 6 dot লিখিব মহন্তৰ standing of APSC, submitted লিখিব তাৰ তলত লিখিব para 6 য'ত ঠিক হৈছে তাৰ পৰা লিখিব Mr. Dotto has submitted that he has received instruction to the effect that the responding APSC authorities are examining the cases of other candidates whose applications have been rejected on the same ground, that is non-submission of COP, certificate of practice, quote unquote. And a decision is likely to be taken in that connection. That's all. Full stop. Okay, para 11 ও লিখিব para 11 ঠিক আছে para 12 okay para 13 এটা লিখিব since the date of interview stroke vivacy for the post of today, what is the
Legal assistant.
Junior Legislative
1
Council,
minute. Where is that?
page 44,
Page 40,
serial number 1.
44. Since the date of interview, stroke vivacy for the post of page 44, serial number 1, Junior Legislative Council and Under Secretary to the Government of Assam, Legislative Department is scheduled today, that is from 9 a.m. onwards, scheduled today from scheduled today, 9/9/2025, 9/9/2025, this court. It is observed that in the event it is not possible to hold the interview stroke vivacy for the petitioner today for the said post, the APSC authorities.
Perhaps he has the
If
instruction.
not possible.
He has the instruction to have.
Okay.
We'll come, but Lordship may observe in like way. That it will have in other candidates.
No. We'll just observe.
Yes,
If he holds, then it is okay. Scheduled today, 9/9/2025, from 9 p.m. onwards. It is observed that if for any reason the responding APC authorities are not in a position to hold the interview stroke vivacy for the petitioner for the said post today, the responding APC authorities are at liberty to hold the interview stroke vivacy for the petitioner at any other convenient date. Any other date convenient to the respondent APSC authorities. Because for some reason it may happen. So that I am giving the liberty.
Including the similarly situated.
No, that I cannot. Full stop. Having considered the submissions of Mr. Dottol and his standing counsel, last para. APSC, that there are other candidates whose applications are rejected on the ground of non-submission of quote unquote certificate of practice. And APSC authorities are considering their cases, comma. And it is observed that the APSC authorities are at liberty to take appropriate decision in that connection.
Lordship.
I think that was,
Lordship.
will not say that you
Lordship.
take that, it is your liberty.
Lordship.
That will do? Any other change?
It may be listed along with the other one, my lord, on 5 to
That
9.
will do. Baki, all are same.
Rest everything, sir.
4 weeks, any date?
But date has not
15-10.
been fixed.
15 day, returnable 15 day, same day,
Lordship.
same day.
Yes, same date.
That will do.
Lordship.
We'll not say that together.
Lordship.
15 day. Only any change.
Obliged.
I take by your, I have not seen.
No, my lord, he's
Both
there.
of you have seen?
No,
He's there.
all are advocate, Lordship.
And that I know, no. Any correct, case
Everything
paper,
is
I have not seen the annexers and all.
Everything is said.
Everything is.
Everything is.
I am going by your words.
Lordship.
Obliged.
For admission,
Itu mari দিব. Kale mari দিব.
item number 13.
Mr. Doctor, you convey the interim order passed in this petition. If that can be done, because otherwise all the interviewers have to call, be called again. If that petitioner is already in the APSC office.
He has, just now he has already rushed to the APHC office, and I have
Okay.
also instructed to keep one board hold.
So today, if it is held today, it is better. Otherwise, everything has to be
Lordship.
rearranged.
No.
So he is there already.
Lordship.
We'll upload it
Lordship.
during break.
Obliged.
Item 13.
Here in this. Lordship, I am appearing on behalf of A. Gayan, Lordship. Please need some accommodation, Lordship. Today, Lordship.
For today.
For today, Lordship.
Yes, Mr.
Lordship, it may be Lordship.
Mr. N. Upadhyay, Learning Council. Gani is not available today.
She is in different court also.
Okay. Appearing for Ms. A. Gayan, Learning Council, but the petitioner has submitted that Ms. Gayan has personal inconvenience today to appear in the case and has thus wait for listing of the case another day, on another date. Post of Mr. J.K. Goswami, additional senior government advocate, appearing for the state respondents, has accepted the submission of Mr. Upadhyay. Post of, let the case be listed. What is the case about?
The compassion at the time.
Compassion appointment. Let the case be listed about after a week when I date to expire.
How like?
2016. By this pendency itself spent its force.
Item 21.
It is 22 হয়ে গেল, no? 22 হয়ে গেল।
May I please, my lord? My lord, can it be taken after some time? My senior Mr. S.P. Chaudhary is not available right now. Just one. Times. Yes. Well,
After some time.
maybe.
Yes, what is the matter about
My lord,
selection process?
no, my lord, this is the regularizations. They are working for more than 30 years, and there is a decision resolution to take to regularize them against the sanction post. It was not done. Then at least this honorable High Court has given direction to consider it. That was not considered. That is why he approached, my lord. So our case basically, my lord, that we are working against the sanction
One
post.
minute. 1 minute, let me find out. আমার কেটে পাঠের আছে পাঠের কেটে আছে আমার Yes, Mr. Bora, can you be on some other date?
Yes.
Because we have two partner matters.
Yes.
Yes.
That may be fixed, my lord.
Okay, we'll put it on a fixed date. MJ Borua, Learned Counsel for the petitioners and Mr. S.P. Chaudhary, Standing Counsel,
NIT.
NIT, Silchar,
Yes, Lordship.
are present as sought for and agreed to by the learned counsel. But the parties, when, tell me?
After vacation, after any date after
Any
vacation.
dates? Any date means October second part. Can it be on 30, Thursday?
30th of October, Lord.
Huh?
Obligation.
30, 2024. 30.
30.
Thursday.
Obligation.
Item number 22.
May it please your lordship. Lordship, my senior is on legs, therefore at 2 p.m. your lordship.
2 p.m. we have fixed this Mr. P. Bora, senior counsel's case, item number 24. 24. That it was mentioned day before yesterday itself. I put it at 2 p.m.
Lordship, then since my senior is on legs, lordship.
I have two part-head matters.
Okay, lordship.
Two part-head.
So then some other date this week.
Can it be on Tuesday?
Tuesday, your lordship. If your lordship doesn't, can I check the schedule? Could be 9. Not right, September 15th. Tuesday will be 15th, your lord. 16th, your lordship.
16th? Convenient.
Lordship 16th.
16th, convenient? Okay. Mr. T. Kashyap, Learned Counsel for the petitioner. And you were for? Lina. Okay. Mr.
Arsang.
Arsang. Arsang. Learned Counsel representing Mr. D. Nath. Senior government advocate, some for the state respondents. Post up. Are present as sought for and agreed to by the Learned Counsel for the parties. List the case on 16/9/2025. The interim order past that shall continue till the next day.
Item 23.
Short. We'll take up your case from 2 to 2 o'clock. You come at 2 o'clock.
Lordship, in this matter, petitioner is a retired engineer, Lordship. Right now he is getting provisional pension, but his no due certificate has not been released by the concerned divisional engineer. Because, Lordship, one inquiry was conducted by.
Mr. Chaudhary, I thought from 2 onwards, I have two part-time matters.
Okay.
I have already fixed. So Tuesday? Yes, Tuesday?
Yes.
Interim order has been continued.
Yes.
Tuesday, my lord, I'll pray for in the first half.
In terms of direction passed by the Delhi High Court, Lordship, one inquiry was conducted by the CBI against this person also, Lordship. In the meantime, CBI has already submitted the report before the Delhi High Court. So what is the outcome of that case, Lordship? Whether Delhi High Court issued any specific order for registration of any case or not, that instruction we are not having at this stage. So what the department is contemplating, Lordship, to write directly to the CBI, Lordship, and take information as regard whether any case has been registered against the petitioner or not. That is why his no due certificate has not yet been released and no decision has yet been taken as regard finalization of his pension. That is the status, Lord.
Okay, he was in which department? PWD.
PWD, Lordship. At the relevant time, Lordship, he was the executive engineer, Gulaka.
Oh.
If I may, Lordship. Lordship may kindly pick up the matter after some motion. Senior counsel is engaged in unarmed arrest to speak, Lordship.
Urgency should not be there, Lordship. He is getting provisional pension otherwise.
Where it is mentioned, anything in the affidavit in opposition? Anything in the affidavit or motion?
In the affidavit, Lordship, paragraph 6, Lordship, page 51.
Petition card. No. But they have brought out the decisions. But they have brought out decision. Very good, very good. Or court.
It speaks about some preliminary inquiry.
Yes. That report has already been submitted.
Report,
Once inquiry report has been submitted by the CBI to Delhi High Court.
Delhi High Court.
Yes. 2 cases are pending there, Lordship. In fact, court directed for CBI to
Court
conduct, yes.
Yes, Mr. Das.
My lord, it's a matter regarding pension.
Just a gist first,
I'll give. My lord,
without referring to the documents,
No,
and we'll look into the
I'll
documents.
just look into dates. My lord, he has retired as a superintendent from on 31/8/24. Prior to it, there was a departmental proceeding that has been ended with withholding of petitioner's 1 increment. Now thereafter, my lord, there is no other case pending. My lord, on the basis of the High Court's order, they have given provisional pension. Now, Rule 21 of the pension rules, your lordship will kindly see. They now what they have done is, my lord, your lordship will kindly see that page 45. Page 45, no due certificate, because during certain period he worked in Jorhat.
So
he
departmental proceeding ended with what?
with withholding of petitioner's 1 increment
Withholding of cumulative effect.
with cumulative effect.
So it continued, it will continue. With cumulative effect means it continues. So that increment is gone.
Gone.
So you are happy with that?
We are happy. Yes.
With no appeal by you?
No appeal by.
So this has come to a final.
Yes.
Now, there is another angle that 1 preliminary inquiry was conducted.
Yes.
Right. So the preliminary inquiry may result in a FIR. Regular case.
Yes.
So regular case investigation, then charge sheet trial will end in
Either in acquittal or in conviction. Yes.
conviction. So there is no question of recovery of money.
At this stage,
He will undergo imprisonment if he is found guilty, and recovery of fine, that may be the at best. And if he is convicted, there may be an order for stoppage of pension. Can recovery be made
No, no,
after 1 minute? Can recovery be made from the petitioner as on date if there is no charge sheet? If he is governed by Assam Services pension rules,
Yes.
then a criminal proceeding is said to be initiated on the date of submission of SRC. As on date, there is no criminal proceeding, as per the service rules.
Lordship. That is,
Then there is no bar.
that is my understanding.
Rule
also.
21, my lord.
Department is in a dilemma, Lordship, what to do in such a situation, Lordship. And
What?
for that reason only, Lordship, they have already approved.
You have granted him
Provisional
pension.
That is statutory, Lordship, that we have.
Law says a judicial proceeding or proceeding, departmental proceeding, is initiated on the date of submission of the memorandum of charges.
Lordship, yes.
That itself has attained finality, resulting in withholding of one increment, maybe with cumulative effect.
But so far as DP is concerned, Lordship, it is
Gone.
It is gone.
Now, as on that, criminal proceeding is not there.
That we are not aware, Lordship. That is why, Lordship, that is why I submitted at the very beginning, Lordship.
It is pending since about 1 year. And my lord, your lordship, I'll just point out page 65. Page 65. Just your lordship.
If that is the real intention, you should get it early. Otherwise,
824, my lord, he retired in the month of August. My lord, your lordship will kindly see page 64, 65. With reference to the subject cited above, I have the honor to request you once again to submit the no demand certificate. So no demand certificate, this officer, executive engineer, Golaghat, he is not giving it. Silchar for the period 31/1/2022, 27/7/23. So therefore, my lord, in the absence of this, they are unable to, my lord, proceed with the pension. And this has been issued by the Superintendent Engineer PWD, Silchar to the Executive Engineer Golaghat. And next year, Lordship will kindly see his answer. Executive Engineer, my lord, if there is pension is there, if they want to withhold the pension, the higher authority will do it. Who is the Executive Engineer, my lord? He is not cooperating with the department itself. Now his answer, your lordship will kindly see page 66. His answer is, I have the honor to, it is in the form of an affidavit, my lord. I have the honor to inform you that a letter related to the above
66. Okay.
66. Next page, my lord.
66 subject.
To the above mentioned subject is already being forwarded. Now, till that day, he has not forwarded. As a result, my lord, his pension has been withheld. So I'll just give one judgment, my lord. Annexure D. My lord, on
Dues, I think, Mr. Nayak, you can work out in departmentally. So far dues are concerned.
Flag D, my lord, is the judgment on Rule 21, paragraph 10. Since expert explanation, paragraph 10 of Rule 21 of the aforesaid rules, there is no departmental or criminal proceedings pending against the petitioner. The power of withholding pension either in whole or in part is not available in the instant case. However, it is the governor of Assam which alone is empowered to withhold such pensionary benefit. Here they have given the authority to executive engineer. They are writing and writing, he is not giving anything. Further, the provisions of Rule 21 also provides that in case of institutions of any departmental proceedings not instituted while the officer was in service shall not be instituted save with the sanction of the governor of Assam. Time and again, paragraph 9, Apex Court has emphasized that pension is not a bounty, but the same is a right of the person concerned who has retired from service. The pension rules itself has made several specific provisions for providing pensionary benefit at the earliest opportunity. Now, I have given my lord, he has not got gratuity, leave encashment, and the GPF, besides one regular pension. So I have given my lord flag A, B, and C, my lord, for providing your lordship may dispose of the petition with a direction to provide all the pension and the pensionary benefit within a stipulated time with this, my lord, interest as stipulated by the Honorable Court at flag A, B, and C. It is more than 1 year, my lord, he has been, and the department is just, they are unable to bring a document from their executive. This is what I understand from the pleadings. available before the court. And flag A, B, and C, my lord, I have shown that he is entitled to get interest as per the judgment passed by the apex court. Because there is no delay on his part, my lord. He has submitted, he has prayed for this no due certificate that was not given, even the departmental authorities could not bring out. And as on today, my lord, there is no criminal case, no department.
Yeah. What is your stand in the affidavit? Let us have a look at the affidavit. Who has filed this affidavit?
This affidavit.
And the secretary.
By respondent number 2, yes, Lordship. Paragraph C, your Lordship has already seen.
Let us have a continuous
Yes.
reading so that I can understand. I have not seen the file. Just now I have opened the file.
If Lordship comes to paragraph 4, Lordship, that is page.
So and so he was placed under suspension.
Paragraph 3, Lordship, page 50.
Yes, paragraph 3.
The answering deponent begs to state that while serving as superintendent engineer planning in the office of the chief engineer PWNH work, Assam, he was placed under suspension by the government of Assam by notification number so and so against a case which occurred during his tenure as the executive engineer Gulagat NH division.
Let us see that notification.
Yes, this notification is the annexure 1.
Where it is reported that it's kindly posted.
Page 56.
So the subcontract proposal and subsequently should balance the interest of the developer and the landlord. And just so it is reported that dispose of WPC number so and so by directing CBI to conduct an inquiry.
Yes.
In the matter of
inquiry in the matter of issue of subcontract, and in the tender contract agreement, Lordship, it was not permissible. And he, without taking any approval from the authority, Lordship, he himself allowed subcontract.
This was disposed of when?
This has not yet been disposed of, Lordship. This
disposed of?
Delhi High Court matters
has disposed WBC.
2 cases are pending there, Lordship, in Delhi. One is 9575/2023.
And that's been disposed of as per this order. Case 56, third para.
Maybe some wrong.
It says disposed
so far as
by directing CBI to conduct inquiry into the matter or issue of subcontracting or of the works and also to take action in accordance with law. So it was on that count that he was suspended, then
Yes.
pending trial. Then according to
DP was
petitioner, that has
initiated.
attained finality
Yes, Lordship.
with that infliction of penalty.
Yes.
Then let us see paragraph 2, 3, 4, 4.
The answering deponent begs to state that the Office of the Executive Engineer PWD Golaghat NH Division, Golaghat received a letter from the petitioner while he was posted as the Superintending Engineer PWD Silchar Building Circle, Silchar, dated 23/8/2024, requesting issue of no demand certificate and GIS subsequent certificate statement. From this office, for this, his incumbent period as the Executive Engineer Golaghat NH Division, as he was retiring on 31/8/2024.
Letter from the petition. When it was posted as requesting issues. Okay.
In the next paragraph, Lordship, petitioner wrote another letter to the Office of the Executive Engineer PWD Golaghat NH Division. That is on 18/10/2024.
Basically, no demand certificate.
No demand.
Delhi High Court judgment.
Okay. That should regard to the requirements made in the
Ultimately, pension will be decided by the government, Lordship. Here, only the case of issue of no demand certificate. Then paragraph 6, your Lordship has already read. Answering deponent begs to state that since it was informed by letter number so and so dated 1/5/2025 that the preliminary inquiry number so and so has been registered at CBI Anti-Corruption Branch Guwahati due to certain works carried out during Sri Nirupam Bhattacharya's tenure as the then Executive Engineer PWD Golaghat NH Division. Therefore, in the greater interest of the Office of the Executive Engineer PWD Golaghat NH Division Golaghat, before considering the petitioner's request for issue of no due certificate, wrote a letter to the office on 8/11/2024 seeking consent and necessary instruction. Next paragraph, Lordship. In response to the office letter dated 8/11/2024, Chief Engineer.
This 8/11 was written by whom?
Executive Engineer. The present
To
executive.
this office. To this office means government or what?
To this office means Office of the
The annexer.
Annexer 4 and 5.
5.
4 is to the Chief Engineer, Executive Engineer. No.
4 is to the.
Yes, 4.
4 or 5?
4 by the it's government, Lordship.
Government.
Government.
To the government advocate.
To the standing council.
To the government advocate.
Yes. And yes.
What is written here?
1/5/2025.
No due certificate of so and so has been processed.
Process in ECF file number
The Judicial Department.
Judicial Department and
Since it involves WPC
97/20
and the CBI preliminary inquiry.
number so and so.
And preliminary has been registered. Inquiry report submitted.
By CBI Anti-Corruption
Casting
Branch
so and
in
so.
compliance of order dated so and so, person WPC number, Honorable Director. It is
Okay,
also
some inquiry report submitted.
yes. It is to be mentioned that CBI inquiry was held against the procedural lapses during his tenure as Executive Engineer PWD Golaghat NH Division, and on receipt of an application from Sri Nirupam Bhattacharya, retired Superintending Engineer PWD, for non-issuance of NDC, the matter was processed in the department, that is in government, Lordship. Personnel B department was requested to offer views as to whether NDC can be issued to Sri Nirupam Bhattacharya, retired Superintending Engineer PWD, in which it is advised to obtain views of the ARTP and PG department and Judicial Department. ARTP and PG department also advised to obtain views of the Judicial Department, and as such, Judicial Department is requested to offer views as to whether NDC can be issued to Nirupam Bhattacharya, retired Superintending Engineer PWD, and on receipt of the views of from the department, further necessary action will be taken from this end. Also, it was earlier. Subsequently, views of the Judicial Department was also received, Lordship. It is in the instruction, Lordship, not in the affidavit. Therein, Lordship, it has stated. Now the Judicial Department, I'm reading from the instruction. Now the Judicial Department stated that it could not come across any circular OM provision laying down the norms and criteria regulating issuance of NDC. Therefore, in absence of any provision guiding principle, the department was advised to ascertain if any such rule exists and thereafter take necessary action accordingly. So that is the dilemma the department in. And
nobody knows Where from no due
No,
certificate
so
is
far as
required?
pension is, finalization of pension is concerned, that is a different issue. Rule 21 is there and law is settled there. But so far as issue of non-due certificate, Lordship, that is the dilemma, Lordship. So that is why the executive engineer repeatedly writing to the government, Lordship. No doubt that superintending engineer's letters is there, but government
But-
itself is undecisive at this stage, Lordship.
There is no concept like no demand certificate perhaps.
Yes, that is the views of the judicial department also, no.
Everything originated perhaps for petitioner's application for no demand certificate.
Yes, it started from there.
Now let us see his letter. His Roman 3 annexer.
At page 61, Lord.
59.
Page 59.
59 annexer 3. Your
My
affidavit of position.
Yes, Lord. With reference to above, I am to inform you that undersigned is need of above mentioned certificate along with GIS statement during my stay. As the executive engineer PW at Gulaghat NH revision to process pension papers of undersigned, Lordship. In fact, Lordship, these pension papers are to be processed by the Silchar office, not by the Gulaghat office. He retired from Silchar, not from Gulaghat. Pension papers of undersigned, as undersigned had already get retired from the government servant on 31st of August 2024, which has been already mentioned in the letter mentioned above. But it has been seen that though the correspondence has been done in the month of August 2024, while the undersigned was officiating as a superintending engineer PW Silchar, Building Circle, Silchar, it did not yet issued the above mentioned documents till date, though a considerable time has got elapsed, which resulted in hampering the process of pension papers of the undersigned with the government and Accountant General, A&E Assam, etc. to great extent. It is also observed that you did not do any correspondence neither with the undersigned nor with the higher authority in government expressing your inability to issue the same.
Mr. Nayak, this is a judgment of the Delhi High Court. Delhi High Court, WBC 9575. This is the judgment. Status report. Is it a status report?
Sorry.
This is a status report.
But this is the.
Status report. If I am wrong, I have just read the result of CBI inquiry. I don't know whether you are aware or not. Some self-contained note has been published.
Lordship, so far as my knowledge is concerned, it was clearly mentioned there. His procedural negligence was there in respect of the petitioner.
So
but
far,
no criminality
criminality
is involved. That is there.
Criminality is involved.
So,
what CBI probed
yes.
for conducting criminal investigation on the part of any respondent or petitioner.
So
that is suspect, public servant, subcontractor or the contractor. Otherwise, norms have been so and so. Then CBI has advised or suggested, has been sent to the government of Assam for taking necessary action against one so and so, Nirupam Bhattakur, Abhijit Borua, subcontractor, and so and so. Necessary action.
DP and from that point, DP was conducted, Lordship.
From that point?
Yes. Thereafter, DP was conducted.
And what
already been inflicted, Lordship.
Then what it means?
So only instruction as the department informed me today morning, Lordship. They are only contemplating to have the final word from the CBI that no case has been registered and nothing.
But
against
are you not? You are aware? You have just said no criminality.
In the report, there is at least that point has been made.
And where is the judgment? Where is the judgment?
My judgment in the CBI case.
No, Delhi High Court.
The judgment is not with us.
9575.
Lordship, so far as my knowledge is concerned, these two
But on the
cases have
date,
not yet been disposed
on
of.
the date
Both the
he
cases are
retired,
pending.
there was no disciplinary,
No, no.
proceeding, there is no.
His judgment, judgment is available with you. You are a respondent there.
Not that.
I have the judgment, Lordship. Today, Lordship, I am not having it.
You have got the judgment.
Yes, Lordship.
It has been disposed of.
So far as my knowledge is concerned, these two cases are fixed on 16th of January, Lord. Both the cases.
16th of January 2026.
Next year.
Next year.
My submission before this court is, my lord, as on the date of retirement, no criminal case, no discipline proceeding. As per Rule 21, my lord, he is entitled to get all pensionary benefit. It cannot be held up, my lord, arbitrarily. Since they have delayed on their part, so this petition can be disposed of with a direction for payment of the pension, gratuity, and other benefits.
That is the final relief.
Yes.
So,
It
for
is-
that, I have to see the facts. I'm
Yes,
trying to see the facts only.
Yes, because that judgment by Honorable Justice B.K. Sharma shows clearly, unless there is a departmental proceedings and criminal proceedings, it cannot be withheld. And if the Supreme Court judgment have annexed, if there is any delay.
This page, paragraph 23, Mr. Nayak, may be allowed to be closed. Preliminary inquiry. So, what is the latest? This was filed when?
But so far, it was submitted, but no order has been passed, Lordship. after
This is
submission.
39/2024.
Yes, in the month of, I think, September last year.
September.
It was submitted, but no order.
Then thereafter, when it was listed?
Lordship, last it was listed on 22nd, Lordship, 22nd of last month, Lordship.
What is the order passed?
No any effective order was passed, Lordship. But
Then as on date, there is nothing.
it appears.
So far, criminal prosecution is
But Lordship,
concerned.
my only submission would be, Lordship, it was on the direction passed by the Delhi High Court, this inquiry was conducted. Accordingly, the report was submitted. Definitely, CBI took a view in that report, Lordship. But on that report, court has not yet passed any order.
So a position existing as on today.
No
Is-
DP is there, no
No
criminal
DP is
cases.
there, no criminal prosecution is there. Then rule is to be enforced.
No, Rule 21 for the purpose of finalization of pension.
Yes.
But here we are on the issue of whether a no due certificate is to be issued or not.
That we decide.
That is what I'm.
Nobody has been able to point out.
Yes, nobody
Nobody has been able to point
that
out
is
what is
exactly-
no
that
due
is exact-
certificate.
That is exactly my submission. Petitioner is saying something, I am submitting something.
And
So Lordship
Judicial
will decide.
Department has also
Lordship-
said we are not aware of any no dues
Yes,
certificate.
Lordship will decide.
And
That is-
everybody is writing.
Lordship-
Otherwise, that is inconsequential. For the purpose of pension,
So
you decide about no
only-
dues.
Only thing,
The
Lordship,
question is, why it does not appear that it has any genesis with any statutory rules. So far as Assam Services Pension Rules, it makes no mention of no dues. Right.
it is no.
Maybe some office memorandum, executive instruction may be there.
Which the judicial department
If
was
no-
also unable to
If
find.
no dues there, or if suppose in the no dues certificate says that we have dues there, still you can work out the pension and deduct that amount. Thereafter, another litigation, that is a different issue. You recover always.
So
You always recover. We have litigations. And Rafiq must see white paper for that purpose only. But he is not grade 3 or grade 4. That will be a different issue. But you can always recover. You recover always. We have seen. So if any dues are there possible to be recovered, you recover. Whether legal or illegal, that is a different issue. But
Yes.
otherwise, it has no statutory backing, perhaps.
that appears, Lordship. That appears. So far as the law is concerned, no dispute is there, and it is settled, Lordship.
So far as no
Only
due
that-
certificate, you resolve the issue departmentally.
In that situation, Lordship will dispose of this matter, directing the authority to resolve within 4 weeks or 6 weeks, Lordship.
That can be done. Yes, Mr. Huh?
That is possible.
Okay.
No, I'm just giving one letter addressed to one of the officers available in MAT. I provided a copy regarding why no due certificate is necessary.
Okay.
In whichever office the person works, there may be some canteen dues, some maybe any other dues is there. So unless that dues is given, my lord, they will not proceed with the pension paper. This is very normal. I know, my lord, for a very long time without reading. So I'm just giving the one of the letter.
If he has taken some petty cash from
Yes,
the office.
this has to be informed, and without that, they will not proceed with the pension paper. And government of
I think
Assam coming here, they're
your
saying that we do
finance
not know the meaning of no due certificate.
Because of the department, you are due for retirement.
These are the letter issued.
So basically, no demand certificate
Without that, they will not proceed with the pension paper. The pension paper
are required from the, say, the offices where the employee work.
Yes.
For the purpose of pension, so that any recovery is required to be made, you recover. As on date, I don't think that's, since you have said no effective order in by the Delhi High Court in
Yes,
22nd.
on last date, Lordship, I appeared there.
So meaning thereby there is no FIR as on date. Not to speak of search sheet.
It appears, but why I'm submitting Lordship, court has not yet passed any order on the report submitted by the CBI Lordship. I don't know what order Delhi High Court will pass, Lordship.
No, order has been passed, but I have given a copy.
After submission of the report.
50. No, yes, finally disposal.
Final disposal. Good enough.
On last date also I appeared.
I have given a copy.
You appeared.
Yes. Next date is 16th of January, Lord.
In view of the above, this court is of the opinion that this is the direction the lead petition is dismissed, pending application, if any, also stands dismissed.
9575.
Yes, 9575.
We have seen 9575 only. Any other repetition? Mr. Nayak says two
Two
repetitions.
repetitions are there, one by the main contractor, one by the subcontractor. And the second one is.
Both are listed together.
Yes, both comes together.
9575 disposed of, 95 WPC 9575 and 366 some CM appeal 36639/23 5415/23.
Lordship, two cases are pending. One is 15724/2024 and the other one is 9636/2024. So this is disposed of. 23 case has already been disposed of. Thereafter also, Lordship, two cases are pending. One is 15724/2024 and the other one is 9636/2024.
You say 9575 2023.
23 has been disposed of.
That has been disposed of. There is also a decision that while conducting preliminary inquiry and after investigation, CBI submits a search sheet. And there they give opinion that insofar as Mr. X, Y, and Z are concerned, we don't find any criminality, but we advise them, we advise the department to proceed against them departmentally. Supreme Court came down heavily. You have no authority to advise that you proceed against them departmentally. That's much because I know on the basis of certain observation, I argued a case. When I was
that is-
on the other side, on the basis of Supreme Court judge.
Yes.
So here,
In this
by
case-
this writ petition 9575, it only directed the CBI to conduct an inquiry into the issue of the subcontracting of the work in question to the respondent number 7. Whoever is respondent number 7, maybe.
Is the petitioner.
Huh?
I think the petitioner.
Petitioner. You gave the subcontract to you.
No, no. Subcontractor, one Prasi or something like that. If respondent number 7 is Prasi, I think.
No, that order, that
The
is not
other-
reflected. So this CBI, then this is a concept note or whatever by the CBI. When the departmental proceeding started?
Departmental proceeding started, my lord. With suspension was on 12/3/24. Show cause notice was issued on 22/3/24. 22/3/24. That is at annexure 2.
23/2/2022.
22.
An inquiry conduct has found procedural lapses. Self-contained note. Now you have already proceeded departmentally against them.
That is over.
Then that is over. That will be again the initiation of any departmental proceeding will be again double jeopardy.
Not.
Is it not?
But he is not agreeing.
Huh?
He is not agreeing.
No.
One judgment your lordship has mentioned. Going by that judgment, we are not even in a position to conduct a departmental inquiry. But he is not agreeing till now. Lord.
Since I could not lay my hand to that, I will not observe that. But so far, you proceeded already before CBI advice. You proceeded against him departmentally and inflicted the punishment.
Once we came to know about the investigation, before CBI submits its report, we started.
So CBI advised. Now it is up to you. If you
It was
initiate, that is a different issue. But as on that, nothing. No order of any, no registration of case. Maybe they have already advised.
That we are not aware.
No.
That is what I am.
Ultimately, it is the Delhi High Court who has to direct. We do not accept.
After submission of this report, court has not yet
passed any effective order. Meaning thereby, otherwise, if this is to be not accepted, it is the only Delhi High Court.
Yes.
As on that, no order, effective order.
Yes.
Whether they have accepted this or not accepted this.
Yes.
So they are meaning thereby there is no FIR.
Appears.
And there, meaning thereby there is no charge sheet. Then pension rules comes and not even certificate is an internal departmental issue that can be decided.
What?
Okay, good.
Just one observation of lordship will make. If in future, Delhi High Court passes an order for registering a case or whatever, in that situation, lordship will keep the option open for us.
We say as on date, we'll say as on date, we'll proceed on the premise that as on date, there appears to be no FIR. So there is no question of any report under Rule 21 or 22.
21, yes.
Because 3 issues, 1 plaint, 1 memorandum of charge, or a report of the police.
Yes.
And that has been interpreted as search sheet, final report.
Lordship.
Under 173 CRPC. That is concept is clear.
That is settled.
So as on that there is nothing, they can work out. Department authorities can work out. So we'll proceed at 2 o'clock.
2 o'clock,
You
I've got
dictate.
one matter in court number 10. So can I put somebody or?
We'll dictate this order.
Yes, and somebody will be there, my lord.
We'll dictate this order. Yes. But somebody should be here to assist me. I have not seen any document except the external document you have given to me.
Lordship. Lordship. I will be there.
After that.
Item 23.
The present writ petition under Article 226 of the Constitution of India is preferred by the petitioner seeking inter alia a direction to the respondent authorities to disburse his retirement benefits, including GPF means General Provident Fund, General Provident Fund GPF, leave encashment benefit, group insurance scheme, GIS and gratuity, along with regular pension. Full stop. A further direction has been sought for to grant interest at the rate of interest from the date of the pension due, that is 31/8/2024. Post. The case of the petitioner, in brief, is that he was a member. Is there any service rules? PWD service rules. PWD की रकम नहीं PWD rules. He was a member of the Assam Engineering Public Works Department, Medical Service. Post of the conditions of service of the members of the Assam Engineering Public Works Service are governed by the Assam Engineering Public Works Department Service Rules 1978. A set of rules framed under the proviso to Article 309 of the Constitution of India. Full stop. Para. On 12/3/2024. The petitioner was serving as superintending engineer, PWD, within bracket planning, O/O, the chief engineer, PWD, within bracket NH works, bracket close, Assam, under the public works, within bracket buildings and NH, bracket close, department. Full stop. By an order, by notification, dated 12/3/2024. Issued under the hand of the Special Commissioner and Special Secretary to the Government of Assam, Public Works within bracket B, Roman and NH bracket close department. The petitioner was placed under suspension under Rule 6 within bracket 1 within bracket small a of the Assam Services within bracket Discipline and Appeal Rules 1964 within bracket 1964 rules password of 1964 with immediate effect pending drawal of disciplinary proceeding. Full stop. In the notification dated 12/3/2024, it was mentioned as reported by the respondent number 3 by the letter dated 26/2/2024 that the petitioner, while working as superintending engineer, PWD, within bracket planning, postal code, the chief engineer, PWD, NH Works Assam, had failed to maintain absolute integrity in discharging duties as executive engineer, PWD Golaghat, NH division, authority representative in execution of a scheme, quote, strengthening of pavement from KM 61/00 to KM 69/00 and widening of 1.5 m paved soldier is 19% on either side and strengthening from KM 10 so and so up to EPC or job number so and so. First paragraph. The subject work for short. It was mentioned that the petitioner had accepted subcontract proposal and subsequently issued performance certificate to the subcontractor without prior intimation and approval of the respondent number 3, thereby, violating the terms of the contract agreement, as reported by the respondent number 3, in his letter dated 26/2/2024. Post of. The notification further mentions that it was reported that the Honorable Delhi High Court had disposed of a writ petition, WBC number 9575/2023, wherein a direction was made to the Central Bureau of Investigation to conduct an inquiry into the matter of issue of subcontracting in the subject work and also to take action in accordance with law. Full stop. The governor of Assam, having been satisfied that it would be necessary and expedient to place the petitioner under suspension from service with immediate effect, the notification came to be issued. Full stop.
Lord, my friend will be there. Please,
Huh.
Mr. Lord.
Para. Now, notification dated 12/3/2024 was followed by a show cause notice dated 22/03/2024, issued under Rule 9 of the 1964 rules, read with Article 311 of the Constitution of India, asking the petitioner to show cause as to why any of the penalties under Rule 9(7) of the 1964 rules should not be inflicted on him on the three number of charges framed therein. Full stop. A statement of allegation, comma, a list of documents and a list of witnesses were enclosed to the show cause notice as enclosures. Full stop. On being served with the show cause notice dated 22/03/2024, comma, the petitioner submitted his reply to the show cause notice on 15/4/2024, traversing the statements mentioned in the show cause notice. In his reply, comma, the petitioner had refuted the allegations brought against him by the show cause notice. Full stop. Subsequently, on 20/04/2024, the petitioner submitted an addendum to the written statement of defense in continuation of his previous written statement in defense, providing, giving certain clarifications. Full stop. Para. Please take a note if I go wrong. The petitioner stating that his suspension period had been prolonged without holding any review comma, preferred a writ petition, comma, WPC number 3907, so 2024. Before this court seeking a direction to set aside the order of suspension dated 12/3/2024 with a further prayer to reinstate him into service. First of, during the pendency of the writ petition WPC number 3907/2024, comma, a notification came to be issued on 19/8/2024 by the Secretary to Government of Assam, page 37. Public Works within brackets B and NH Department. Whereby the petitioner was reinstated in service, comma, without prejudice to the disciplinary proceeding drawn up by the so-called notice dated 12/22/3/2024 and the preliminary inquiry number registered by the CBI, comma, Anti-Corruption Branch, Guwahati. Full stop. The notification further mentioned that on being reinstated, comma, the petitioner would be posted as Superintending Engineer PWD, Silsor Building Circle, against an existing vacancy. In view of issuance of the notification, comma, the writ petition WPC number 3907/2024 was closed by an order dated 21/8/2020. Para. Close on the heels of the notification dated 19/8/2024, whereby the petition was reinstated into service. The petitioner stood retired from service on reaching the age of superannuation on 31/8/2024. The Special Commissioner and Special Secretary to the Government of Assam Public Works B and NH Department, page 41, had issued a notification to that effect by directing the petitioner to hand over the charge of Superintending Engineer PWD, Silsor Building Division, to an executive engineer in the division. Full stop. Para. Just a day prior to the petitioner's retirement on superannuation, comma, that is on 30/08/2024, comma, the disciplinary proceeding drawn up against the petitioner had been disposed of by an order passed even that passed by the Secretary to the Government of Assam Public Works Building and NH Department. Full stop.
by the order dated 30/2024, comma, the petitioner was inflicted a penalty by ordering withholding of one increment with cumulative effect under Rule 7 within bracket Roman 2 of the Rules 1964. Post op. It was further observed that the period under suspension, the petitioner was under suspension shall qualify for pension and pensionary benefits only, and the pay and allowances for the suspension period shall be limited to the subsistence allowance paid to him or ordered to be paid to him. This is 43. Full stop. Para. From the order dated 30/8/2024, comma, it is evident that after issuance of the show cause notice and submission of the reply to the show cause notice, comma, an inquiry officer was appointed to inquire into the charges framed against the petitioner. Full stop. The inquiry officer submitted an inquiry report on 30/05/2024 holding that the charges leveled against the petitioner were proved. Full stop. On receipt of the inquiry report, comma, the disciplinary authority forwarded the inquiry report to the petitioner as the delinquent officer to submit his views on the inquiry report. Full stop. The petitioner submitted his views in respect of the inquiry report on 16/7/2024. Full stop. The disciplinary authority had thereafter, comma, upon consideration of the inquiry report and the views presented by the petitioner through his representation, comma, decided to inflict the penalty, comma, mentioned above, comma, in consultation with the Assam Public Service Commission. Full stop. Para. It is submitted at the full stop. It is an admitted fact that the petitioner did not prefer any appeal challenging the order of penalty imposed on him by the order dated 30/8/2024, comma, meaning thereby, comma, the penalty, order of penalty has attained the status of finality. Full stop. Para. At this stage, comma, it is pertinent to mention that the order dated order of penalty dated 30/8/2024 made a mention about preliminary inquiry number
so and so, which had been registered by the Central Bureau of Investigation, Anti-Corruption Branch, Guwahati. Post. I have heard Mr. B.T. Das, then a senior counsel, assisted by Mr. H.K. Sharma, then a counsel for the petitioner, and Mr. P. Nayak, then Traditional Advocate General, Assam, for the response number 1, 2, 3, and 5, and Mr. C. Borua, then Standing Counsel Accountant General for the respondent number 4. Post. Mr. Das, then senior counsel appearing for the petitioner, has submitted that as the petitioner has already retired from service on superannuation on 31/8/2024. The matter of pension and other retirement benefits of the petitioner is to be considered under the provisions of the Assam Services Pension Rules 1969 rules. Post. He has submitted that the respondent authorities in the Public Works Department have not processed the case of pension and other retirement benefits of the petitioner, particularly on the ground that the Office of the Executive Engineer, Golaghat NH Division, where the petitioner served at one point of time, has not issued a no demand certificate. Post. He has further submitted that the matter of pensionary benefits has not been processed properly in view of the preliminary inquiry, preliminary inquiry number so and so, stated to have been conducted by the CBI. Post. He has submitted that the preliminary inquiry was directed to be conducted by the CBI. By the Honorable Delhi High Court in a writ petition, WPC number 9575/2023. Post. Placing on record a letter number 8, page 16 was 8 folder, blue tag. Number so and so dated 27/9/2024.
of the CBI and Anti-Corruption Branch, Guwahati. Addressed to the Chief Secretary to the Government of Assam on the subject inquiry of CBI ACB Guwahati case number so and so. That's REG. Mr. Das has submitted that the CBI, after holding preliminary inquiry, did not find any criminality for probing and conducting criminal investigation by the CBI. Full stop. In his letter, in the letter dated 27 by the in the letter dated 27/9/2024, Supra. The CBI had only advised for taking necessary action against the three named officers of the PWD and the contractor and the subcontractor involved in the subject work. Full stop. The CBI in its preliminary inquiry had reported about commission of procedural lapses on the part of the petitioner who are the subject work. Full stop. Mr. Das has further submitted that there is no FIR, no case, criminal case registered against the petitioner against the alleged procedural lapses committed by the petitioner in respect of the subject work, not to speak of submission of any charge sheet after completion of the of any criminal investigation by the CBI or any other investigating authority. Since as on date, there is no charge sheet against the petitioner after any criminal investigation, the respondent, the inaction on the part of the respondent authorities in not processing
the case, the matter of pension and other retirement benefits of the petitioner is arbitrary and unjustified in the context of the provisions contained in Rule 21 of the 1969 rules. Full stop. He has thus contended that the direction as sought for as sought for is clearly called for. Close stop. Para. Mr. Nayak, learned additional advocate son, appearing for the responding authorities in the Public Works Department, has submitted that apart from the writ petition, WPC number 9575, 2023, filed before the Honorable Delhi High Court. There are two other litigations, Lordship, in the form of nothing in the record.
Nothing on
Two other litigations
two other
are still pending
Lordship.
before the Honorable Delhi High Court. Full stop. In the matter of non-issuance of no demand certificate, comma, Mr. Nayak has submitted that has referred to the affidavit in opposition filed by the respondent number 2 to submit that the government in the Public Works Bill B and NH department sought for views of the personnel department, comma, what is ARTP administrative reform,
Administrative reform.
comma, administrative reform, ARTP means
Administrative reforms, training.
training, comma, pension and public grievances department within bracket ARTP Roman and PG department and the judicial department in that connection.
That is the latest position.
Full stop. The personnel department, in response to the query, the personnel department advised to obtain the views of the ARTP Roman and PG department and the judicial department. Full stop. The ARTP and PG department had in turn advised to obtain the views of the judicial department. Full stop.
The judicial department had observed that it could not come across any circular stroke office memorandum stroke provision laying down the norms and criteria regulating issuance of no demand certificate. Full stop. The judicial department had observed that in the absence of any provision stroke guiding principle, comma, the public works department should ascertain if any such rule exists and thereafter, comma, take necessary action accordingly. Full stop.
Lordship, although there no due certificate has been mentioned, Lordship, it should be actually no demand certificate.
No demand.
In the
No demand.
in page 45 of the red petition, a request was made for no demand.
No
certificate.
demand.
And in the pension proposal also, there is a specific checklist, Lordship. In the checklist also, it is mentioned as no demand certificate.
Mr. Nayak has further submitted that when a case for processing the pension, when a matter of pension is to be processed, comma, a no demand certificate is a requisite.
It is a, yes, it
Yes,
is
it is a requisite.
for assessing pension and gratuity.
Is a requisite for working out the pension and other retirement benefits to an retired employee. Full stop. Otherwise, there is nothing in the affidavit.
Nothing.
This is all.
That is the only thing.
Full stop.
And so far as
he has fairly submitted that the Honorable Delhi High Court, by an order dated by its judgment dated 16/2/2024, passed in the writ petition, WPC number 9575/2023, had disposed of the writ petition, and while and it was disposed of with a direction to the CBI to conduct an inquiry into the issue of subcontracting of the work, subcontracting of the subject work, and also to take action in a matter in accordance with law, and to submit a report to the Delhi High Court. Full stop. The CBI, after holding a preliminary inquiry, has submitted its report, inquiry report, on 27/9/2024 with an advice to proceed against the officials of the department who had, in respect of whom the CBI had recorded about committing of procedural lapses while executing the subject work. And the petitioner was one of the officials named by the CBI in its inquiry report.
Lordship, my submission will be, once this issue is resolved, Lordship, whether in the particular situation of this case, a demand certificate should be issued or not. And if a decision is taken in favor of issuance of the notice,
submitted by him that this action suggested by the CBI in its inquiry report is to be resolved and after such resolution only the matter of no demand certificate
Could be decided.
could be decided.
And if it is decided in favor of issuance of no demand certificate, the pension proposal of the petitioner will be moved.
If the decision is in favor of the petitioner, then only the matter of pension can be further processed.
Not. That is fine.
Okay. Full stop. Para. I have considered the submissions of the learned counsel for the parties. And I've also gone through the materials brought on record by the parties through their pleadings. Full stop. Ah. Mr. Burwal, I am standing as Accountant General has submitted that the pension papers have not yet been forwarded by the respondent, by the Public Works Department, Government of Assam, to the Office of the Accountant General, ANE Assam, till date. And as such, there is no question of processing the pension. Working out.
The GPF we can pay, but what I meant, accounts number we have not seen.
For working out and disbursing the pension and other retirement benefits to the petitioner.
We will get number, account number.
We'll not go with that technicality.
Yes, then no.
Full stop. Para. On a plain reading of the show cause notice dated 20 on a plain reading of the contents of the show cause notice dated 22/03/2024 and the charges leveled therein, comma, it can be noticed that the charges were framed with regard to the petitioner's tenure as Executive Engineer, PWD Gulaghat NH Division, come authority representative for implementation of the subject work. And commissions and omissions committed by him in connection with the subject work. Full stop. The disciplinary proceeding initiated by the show cause notice dated 22/03/2024 was taken to its logical conclusion taken to its conclusion by the order dated 30/8/2024, whereby the penalty, as noted above, was inflicted upon the petitioner. Full stop. With the petitioner not assailing the order penalty imposed on him by way of any appeal or any other form, the order of penalty has clearly attained finality. Full stop. Para. In the self-contained note appended to the letter dated 27/9/2024, of the by the CBI of the CBI, which was addressed to the Chief Secretary to the Government of Assam, it was reported that the officials of the Public Works Department NH Division, Gulagat, failed to seek approval of the authority, that is the Chief Engineer PWD NH Works Assam, for accepting the subcontracting in respect of the subject work. Full stop. It was reported that the petitioner had issued a performance certificate violating in violation of the norms it was suggested to the effect that action as may deem fit can be initiated against the erring officials in the Public Works Department, NH Division, Gulagat. Post.
A status report submitted by the CBI before the Honorable Delhi High Court on 39/2024 has also been placed before this court. In the status report submitted by the CBI before the Delhi High Court, the CBI had reported the result of the preliminary inquiry to the effect that the inquiry did not reveal any criminality worth CBI probe for conducting criminal investigation on the part of any of the officials of the Public Works Department, NH Division Golaghat, and a contractor and a subcontractor involved with the subject work. Similar suggestion of taking necessary action against the erring officials and the contractor and the subcontractor for procedural lapses were suggested in the status report submitted by the CBI before the Delhi High Court. Para. There is no material placed before this court to the effect that after submission of the after the letter dated 12/8/2024, 27/9/2024 of the CBI addressed to the Chief Secretary Government of Assam and submission of the status report by the CBI before the Delhi High Court on 39/2024, any criminal case has been registered against the petitioner initiating criminal investigation. Para. Insofar as regards the no-demand certificate is, insofar as the no-demand certificate is concerned, it is found that when the Public Works Department sought views on it from the Personnel Department, ARTP, and PG Department, and Judicial Department, the Personnel Department and ARTP Department had suggested the Public Works Department to obtain the views of the Judicial Department. The view of the Judicial Department is to the effect that it could not come across any circular stroke office memorandum stroke provision laying down the norms and criteria regulating issuance of no-demand certificate. And therefore, in the absence of any provision stroke guiding principle, the PWD department was advised to ascertain existence of any rule
in that connection, and thereafter to take necessary action accordingly. Full stop. On a query, comma, the additional advocate general has clearly submitted that he has not come across any of his memorandum stroke, or he has not been furnished he has not been provided any information with regard to existence of any office memorandum, notification, etc. Full stop. He has submitted that it is a requisite. A no-demand certificate is a requisite for forwarding the papers to the for processing the matter of pension and for forwarding the papers to the Office of the Accountant General for sanctioning the pension and other retirement benefits. Not this is not supposed to. It has been submitted that if any employee has any liability which is recoverable from him.
That will be another certificate. No liability certificate is another certificate.
Okay, on another. Actually, I have found that no demand certificate is from this letter.
That is the
actually from the estate officer, executive of engineer, PWD, in respect of those availing government accommodation. I have seen this actually.
Probably it is limited to that only.
That I know. Since you are not submitting anything, despite being counsel of the public
Lord, the
department, I have not
department
recorded.
itself is not clear, Lord.
Huh?
It is beyond my.
Because this was reported to advance notice of retirement. Just a sample. Bharat Bhushan Devsuri, IAS Secretary.
Lordship.
It is in there. The personal department asked for no demand certificate from estate officer, executive engineer, PWD, in respect of those availing government accommodation.
Yes.
No demand certificate.
In the checklist also exact.
That is the checklist.
Yes. That is the part of the checklist.
So this is actually, if he occupies any government accommodation, then PWD has to give the clearance. Actually, it is the executive engineer. That I know that much.
In the checklist also it is mentioned as executive engineer PW.
But he himself is not
He is not taking a decision, Lordship, because of the pendency of the case, Lord. Not just one executive engineer, the subsequent executive engineer also following the same path, Lord.
From the correspondences annexed to the affidavit in opposition under respondent number 5(2), it is noticed that the different officials in the Public Works Department have been exchanging correspondences in a matter of issuance or otherwise of no demand certificate without taking any decision on it. First of all. None of the authorities who have been exchanging the correspondences have highlighted, has referred to any office memorandum, stroke, notification of the government with which in respect of which, providing for no demand certificate. Post of. Para. It is an admitted fact that after conclusion of the disciplinary proceeding on 38/2024, the petitioner was allowed to go on superannuation, go on retirement after reaching the age of superannuation on 31/8/2024. Post of. For rendering long service, the petitioner is entitled to receive pension, a monthly pension on and from 1/9/2024. Post of. The petitioner is also entitled to receive other retirement benefits subject to the provisions of the Assam Services Pension Rules as a member of the Public Works Service. Post of. But at this juncture, it is relevant to refer to the provisions contained in Rule 21 of the Assam Services Pension Rules 1969. Post of. For ready reference, Rule 21 is quoted here in below. For you. Para. The meanings of quote departmental proceeding and quote judicial proceeding have been provided in the explanation to Rule 21. Full stop. As per explanation small a, this. As for and full stop. Explanation B has provided the meaning of judicial proceeding, quote unquote. And as per explanation B, applicable. It is true that apart from disciplinary proceeding, and a government servant can also be proceeded criminal, can also face criminal proceeding. Full stop. From explanation B small 1, Roman 1. It is discernible that a criminal proceeding is to be deemed to be instituted on the date on which the complaint or the report of a police officer on which the magistrate takes cognizance, is made. Full stop. Very good. CRPC, IPC. From the provisions, the provisions contained in BNSS. from the provisions contained in section 190 Code of Criminal Procedure 1973. Stroke. Section 14. ভারতীয় নাগরিক সুরক্ষা আইন 2023. The provision of taking cognizance of offences by magistrate has been provided in so and so and so and so. Offences on a complaint or a report has been provided in section 190 or section 210 BNSS. As per the said provisions, the magistrate of competent jurisdiction can take cognizance of any offense upon a police report of such facts. Full stop. Section 23R of the CRPC. Stroke. Two T BNSS has provided the definition of police report. Full stop. Quote unquote, police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173 stroke. Subsection 3 of section 193 BNSS. Post. Therefore, as on date, in the absence of any report indicated in Rule 21, read with explanation, B small Roman 1 of the Assam Services Pension Rules, 1969. There is nothing on record to hold that any judicial proceeding has been instituted against the petitioner on date. Full stop. On the other hand, the disciplinary proceeding has already come to an end, attaining a status of finality. Full stop. In any view of the matter, Adjourn date, comma. There is nothing for the state government, the respondent authorities to exercise the right of ordering recovery from pension of the whole or part of any pecuniary loss caused to the government in the absence of any pending disciplinary proceeding or judicial proceeding or resulting in a verdict of guilt against the petitioner for grave misconduct or negligence during the period of service. Full stop. Para. Even a contention has been advanced. Sorry. Though a contention has been advanced as regards no demand certificate, comma. It is it is noticed that there is no provision in the Assam Services pension rules as regards no demand certificate. Full stop. Even if the provision for no demand certificate has been made in any office memorandum stroke notification, comma. The such the matter of no demand certificate is a intra-departmental matter. I think intra-departmental matter, which can be resolved by the departmental authorities in the Public Works Department. Post stop. Para. It has been consistently held that though right to property is no longer a fundamental right, comma, it is still a constitutional right, as provided in Article 300, capital A of the Constitution of India. Post stop. In this connection, comma, the following observations made by the Honorable Supreme Court of India in State of Jharkhand and others versus Jitendra Kumar Srivastava and another, 2013, 12 SSC 210. Made by the so-and-so. Has made the following observations. Para 16. The fact remains that there is an imprimatur to the legal principle that the right to receive pension is recognized as a right in property. Article 300A of the Constitution of India reads as under. Once we proceed on that premise, the answer to the question posed by us in the beginning of this judgment becomes too obvious. A person cannot be deprived of his pension without the authority of law, which is the constitutional mandate enshrined in Article 300A of the Constitution. It follows that the attempt of the appellant to take away a part of pension or gratuity or even leave encashment without any statutory provision and under the umbrage of administrative instruction cannot be countenanced. it hardly needs to be emphasized that the executive instruction are not having statutory character and therefore cannot be termed as law within the meaning of the aforesaid Article 300A. On the basis of such a circular, which is not having the force of law, the appellant cannot withhold even a part of pension or gratuity. As we noticed above, so far as the statutory rules are concerned, there is no provision for withholding pension or gratuity in a given situation. Had there been any such provision in these rules, the position would have been different. There are 16 and 17. Better. It is an accepted position that pension, gratuity, and other retirement benefits are not bounties. Full stop. An employee earns these benefits by dint of his long, continuous and long and continuous service. Full stop. It is thus a hard-earned benefit which accrues to an employee. Whose right to receive pension has been recognized as a right to property by the Constitution bench judgment in Devakinandan Prasad versus State of Bihar. Wherein it has been observed that an employee could be deprived of the pensionary benefits only by an authority of law, and that pension does not cease to be property on the mere denial or cancellation of it. Full stop. The character of pension as property cannot possibly undergo. No, again. There. In the light of the discussion made above, and for the regions assigned, this court has reached a clear view that there is no authority on the part of the respondent, on the part of the authorities in the respondent public works department to withhold the pension and other retirement benefits. Like GPF leave encashment benefit, CIS, and gratuity. To the petitioner, which the petitioner is eligible to receive as per on the strength of his service rendered till the date of retirement. So, therefore, this writ petition is allowed by directing the respondent authorities, the authorities in the respondent Public Works Department to take necessary steps for processing, to process, work out, and disburse the monthly regular pension and other retirement benefits like so and so, with the assistance of the Accountant General, Assam, so that the petitioner receives the benefits within a period of 2 months from the date of submission. Not like it is an inter-party order, so I'm sorry. Inter-party order from today, within a period of 2 months. He is saying 8 weeks, I have extended it more. So,
if he's sending late, I will be
2 weeks or 2 months from today, full stop. It is further observed that in the event, the petitioner, the benefits of regular pension and other retirement benefits are not received by the petitioner within a period of 2 months. The same would entail interest at the rate of 6%. 6% per annum from 31/8/19/2024.
They should send in 10 million now.
Huh?
After 2 months, they send 10 million. If they send complete after 2 months, in 2 months, we never understood.
Constitutional bench has given interest. How can I?
But the intent I'm not about. My lord, if he's sending late, suppose 2 months, after 2 months he's sending.
No demand certificate is a matter of 1 minute. That is regarding to occupying government accommodation. Government quarter. That is a matter of 1 minute.
That is here also. Our law.
And even if after criminal prosecution, suppose CBI initiates, Delhi High Court directs, you have power under Rule 21 to withhold.
Not.
As on that, it is nil.
That is there.
If he is convicted in a criminal prosecution, supposedly,
Yes.
very dim chance,
Remote chance.
very remote, 1%.
Not.
Let us be practical.
It will be compliant. It will be.
You need more months, tell me.
Lordship will
For interest.
extend the period. Lordship will extend the period of 2 months. Ultimately, he will receive. Now also he is receiving provisional pension.
Okay. You seek a extension. If you need, seek extension.
No, Lordship will, at this stage, Lordship will make it 3 months, Lordship. If required, Lordship.
Let it be in 2 months. If they say they will take it.
You seek extension, I will provide 1 more month.
Lordship. Obliged.
Obliged.
Yes, Mr. Bora.
Third method for hearing. Item 24.
It has taken a toll. But you go slow. Any other matter, you were waiting for some other matter? Which one?
Number 27 and 28.
27, 28. We don't think it will be possible.
I don't think possible, can a date be fixed, my lord, in this matter?
2024 matter.
My lord, what has happened is,
It is not fixed, it has come.
but we have,
We are struggling with how much? Sir, it is 2012. So if we go on fixing 2024 matter, it will be very difficult.
my lord, if I may be allowed to, the problem is that, my lord, right now, initially when I approached this honorable court, we were working under some industrial security force. Right now, what has happened is like this particular department has been given under the direct control of the DGP. Though the DGP was having the control, but direct control of DGP. Now, it is the battalion, it is now known as the Assam Police Battalion. Now, there is a stay operating. Now, what has happened, my lord, when the handing over of this entire department is going on, now, particularly the gradation list of this particular sections of
Let it
officer.
list be there, but it will be left over. Then it is possible to be listed. But this is not a fixed matter.
There is an interim.
If it is left over, then we have to make some order. And Mr. K. Vishwakarma.
Yes, Lordship.
Okay, learned counsel for the petitioner, and Mr. who is there? Mr. J.K. Goswami, learned additional senior government advocate for the state respondents are present as sought for and agreed to by learned counsel for the parties. These the cases after a week on a date to be fixed by the office. The interim orders passed. Interim orders, if any, shall continue till the next day of this.
I'm obliged, my lord.
Next year.
Yes, we can. You be there. You be there.
Yes.
Your matter is of which year?
2013.
2013. Okay. You be there, others may go. Record to yes.
May it please your lordship. My lord, just.
I would have loved
make
to
it-
dictate it, but will not be possible
Well,
for
well,
me. I
I-
don't want to.
My lord, I make it short submissions, just to refresh your lordship minds, my lord. Just give the dates, my lord. Dates are important for the facts. On facts, because of the dates is a very important thing. And others are legal specs, my lord. Now, this person has been arrested on the basis of an Nahakotia police station case of 09/2006 of 379 411 IPC. On 4/2/2006, a vehicle, as per the prosecution case, my lord, the vehicle was loading some iron materials, belonged to Oil India, and on the basis of an information by PW6, that is the security officer of the Oil India. So we have been arrested and the truck has been brought to the police station, Nahakotia police station, that is on 4/2/2006. On that day, on the next day, there is an information for the Railway Protection Force. The constable has informed that there is a property belongs to the railway, and railway officials has come, railway protection has come and sought for inspection of that. But as on 5th, there was no officer in charge in the police station. So on that day, they could not search. The vehicle was not permitted. On 6th, they have searched and found 2,242 of screw belonging to claiming to be the screw of railway. So this is the facts of the case. Now, one cases has been on the basis of 379, we have been sent to the jail. That is on 5th itself. And 6th, they have seized the document, taken to their custody of 2,242 screws. Now, the question before your lordship is this, that they have filed a complaint and we have been convicted. An appeal has been preferred to confirm the order of Must, order of conviction and sentences.
What is this railway case number?
Acha, railway case.
Ah,
Now that is CR case number 37.
no.
There is a complaint case, Milord. After making enquiry under section 8, Milord, they
It
submitted
is
the
a railway property unlawful possession.
Possession Act, Milord.
Okay.
So they have a power under section 8, Milord, and they have made an enquiry, Milord. And after completion of enquiry and after examination of witnesses, they filed a complaint, Milord.
Right. Let me look at, because
My lord.
you will go after making submission.
My lord.
I'll be struggling with the
Definitely, definitely. But just
no assistance. 1 minute.
definitely, your lordship is having a very hard time because of your lordship is not getting a assistance, Milord. So far we are concerned, we get an assistance from our juniors. But whenever sitting on the other side, definitely I always agree that it's very hard because of that you do not get any assistance. Even books have been taken away from buying your lordship also from the deck. That is the problem.
I have my books in my chamber from my professional.
Profession, but even from our services, I like this. I told my juniors to bring the books, but so far your lordship is concerned is you have to take the books on your own from the rack above.
No, that was assistance I had. That was assistance I had. Picking up books, picking up files is not the issue. Going through the file is the issue. That cannot be delegated.
My lord.
Okay, what is prosecution report? Yes, Mr. What is prosecution report? Just to understand. What is prosecution report?
Exhibit 1 is the prosecution.
Exhibit 1? No,
Yes.
Exhibit 20.
Oh, absolutely.
Exhibit 20. Then, okay, there is one complaint. Tell me the dates. Any list of dates prepared, madam? What assistance you are rendering to your senior?
That is why I have just got list of days 4 to
I have to record. That much assistance is not there.
Definitely, but she will give. She will give by tomorrow morning itself. The list of dates.
You should give this, because these are trial court records.
Yes, my lord.
Not repetition, sir. And no paper book.
No paper book.
Mr. Biswas might have not prepared also.
All these days when case was coming and going, that's why.
No, list of dates. 79.
I'll submit it tomorrow, madam. Full details, madam.
Mr. Bora, can I have the judgments?
My lord.
Then only we can, I'll
Yes,
understand.
yes.
The trial court judgment.
Trial court judgment.
Better to have.
Yes, my lord. Trial court judgment. My lord, if you like to
Their dates will be there.
Yes, my lord.
Please. Let us go slowly.
My lord, I understand.
Page 12, madam.
Yes, yes.
No, page 17 of my appeal.
No, 12.
Photocopy. Next one.
12.
12, sorry.
Please.
The case of the prosecution is that on 4/2/2006, at about 16 hours, the complainant received an information through the in charge of RPF Nahakotia regarding interception of one truck bearing number so-and-so at Kottupatar, Nahakotia in front of the scrap dam at 3 hours by Oil Security of Diligence under the supervision of SI Gopal Chandra Bora. Some cut pieces of oil pipes were loaded with other stolen materials and 13 persons were also arrested. On getting the information, the complainant along with SI Z. Gogoi, Constable M. Medhi and Constable P. Khatonia left for Nahakotia.
These are railway police.
Yes, my lord, railway police, what I have stated, on 5/2,
Right.
for conducting an inquiry at the Nahakotia police station. On arrival at the police station, the complainant served a written memo to seek the truck, but due to non-availability OC, my lord, The investigating officer did not permit the truck to be checked. On arrival of the OC at about 6:30 hours, the complainant was permission to check the truck on 6/2/2006. These are the list of dates. 456 dated so and who is seized in connection with Naharkutia PS case number 0906 379 411. On 6/2/2006, the complainant with the staff attended the Naharkutia and found
Naharkutia police station case number 09/2006.
Yes, my lord.
Dated, I think, under section perhaps.
Under section 379 IPC. That was Naharkutia episode, what I have stated in it.
That it is mentioned as dated.
Yes. Oh, dated.
Wrong. Yes.
On 6/2, on 6/2/2006, the complainant and his staff attended an Naharkutia police station to check the truck in presence of the local police, Naharkutia, and found 2,247 numbers of the rail screw, BZ, in the truck along with other stolen materials, which were seized by the Naharkutia police station police in their cases. The rail screws were seized from the custody of Naharkutia police. The Naharkutia police arrested 13 persons, namely so and so, so and so, so and so. I skipped this one. 13. 13 is
No, this is the most important. How you skip? Arrested.
Arrested, my lord. These are, including the petitioner before your lordship, these are 13 Deepak Gupta, my lord. All 13 accused persons were forwarded to the jail on 5/2/2006.
So on that day, he was remanded to custody.
Custody on 5.
1 minute. 5/2.
5/2.
1 minute. Trial court. Trial court case received. Gone through. Oh, we don't have the GR case, right?
No, GR case we cannot, because here is a complaint case only.
What is the GR case otherwise?
GR case, that GR case, but I do not have the GR case of that one. It was Naharkutia PS case only have 0906.
What was the fate of that case? Do you know?
That also I do not know. Whether I have been acquitted or convicted, I have no idea about that one. So therefore, my lord, the complaint was all 13 accused persons were forwarded to the jail at Dibrugarh on 5/2/2006. Thereafter, the railway materials were seized.
1 minute. Mr. Vishwas, if I find out any GR cases available somewhere, that will be a bit better for me.
Yes, because
Please have. Yes.
My lord, I don't think GR case is there.
But there will be some mention.
There may be
Definitely some mention. These IOs, there are so many witnesses, some IOs will mention.
Then the complainant so laws is registered a case number 1206 under section 3A of Railway Property Unlawful Possession Act 1966, in short RPUPA Act, and SI Sri D.D. Das was entrusted to inquire. During the course of inquiry, it came to the knowledge of the inquiry officer that the driver of the seized truck, namely Nagendra Nair, had loaded the railway materials without the knowledge of the owner. The inquiry officer tried his best to arrest the driver but could not do so as he absconded. From the finding of the inquiry, he submitted the prosecution report against Mohammad Kalam Ali, Mohammad Mainur Haq, Mohammad Lukman Ali, Mohammad Shoaib Ali, Mohammad Sahir Ali, Mohammad Shukur Ali, Mohammad Nazimuddin Ali, Mohammad Bahadur Ali, Mohammad Liajan Ali, Mohammad Major Ali, Mohammad Sahidur Rahman, Sri Karan Dubey, Sri Deepak Gupta, and absconder accused Nagendra Roy. During the course of trial against the accused, namely Mohammad Kalam Ali, Mohammad Moinul Haq, Mohammad Lukman Ali, Mohammad Shoaib Ali, Mohammad Sahir Ali, Mohammad Shukur Ali, Mohammad Nazimuddin Ali, Mohammad Bahadur Ali, Mohammad Liajan Ali, Mohammad Major Ali, Mohammad Sahidur Rahman, Sri Korun Dole, and Nagendra Roy were separated as it was reported that the accused person were not available in their given address. However, the accused Deepak Gupta contested the case till its completion. On the basis of the evidence adduced by the prosecution, witnesses charged under 3A of the Railway Property Unlawful Possession Act 1966 is read over and explained to the Deepak Gupta, to which he pleaded non-guilty and claimed to be tried. Prosecution examined as many as 13 witnesses to bring whom it charged, which included the complainant and the inquiry officer. These witnesses were cross-examined by the defense. The accused person was examined under section 313.
Mr. Chaudhary is available. It's available. Another part. Any,
He has left, madam.
he was there?
No.
Any associate? We'll put it in Thursday then. Huh? Yes.
The accused person was examined under section 313 criminal procedure code, wherein he denied the incriminating materials against him and desired to adduce defense evidence. Accordingly, the defense adduced the evidence of one of the witnesses. The witnesses cross-examined by the learned public prosecutor for the railway. I have the argument put forward by both the sides at the bar. Learned public prosecutor.
This part you avoid.
My lord. Points for determination. Whether the accused person can be held accountable for unlawful possession of the seized railway materials. Number two, whether there exists reasonable suspicion of involvement of accused person in stealing the materials from any section of the railways. Whether the prosecution could prove its case beyond all reasonable doubts. The second point is a very important thing. Because there is no FIR, no stolen any reports. So the screws are concerned. And secondly, my lord, I just point out two things, my lord. So for the two is concerned, my lord, there are two different major contradictions regarding this screw. At the time of inspection of the screw, when it had been shown to one of the witnesses, that is PW3, he has shown that there is no IR mark. IR mark is Indian Railway mark. But the PW7, which was claimed to be an engineer and expert of the materials, when he came after about 1 year and to examine, he said that there is an IR mark.
Okay, the summation will read.
My lord. Well, here it's not been recorded. I just point out.
Point out thereafter will.
Yes, I'll point out. I just go through thereafter. Because two is the important thing. Exists is a suspicion. Well, there is suspicion and grave suspicion. There's two things, Miller. The case of the prosecution is admittedly based on the receipt of the information that the truck was intercepted contained railway materials, among other materials loaded in it. Based on such information, PW1 Sri Jibeswar Musahari, PW4 Montu Medhi, Prosenji Khatania so went to the Nahakote police station and after observing formalities, seized the railway materials which were rail screws numbering 2 to 47 among the other presents on the truck, which were primarily materials belong to the oil. The RPF staff took caution in extracting only their concerned railway materials without any kind of bias. PW3 Rupam Chandra Hazarika stated that the PW6 the Gopal Chandra Bora, who belongs to the oil security division, came to his quarter and shown him a screw as a sample to ascertain if he belonged to the railway. On being confirmed by PW6, the witness, one of his colleagues, went to the Nahargarh police station and personally verified the loaded truck and saw some rail screws along some pipes belonging to oil. PW3 then intimated the matter of the so-and-so, along with PW1 and PW30, went to the Nahargarh police station and separated the rail screw from the track and found 2 to 47 numbers of the screw. PW13 also stated that he saw some 13 accused persons arrested in connection with the case of Nahargarh police station. So at that point, the 3 was there, which it has been shown to the 3 million, important million. I'll come later on because your lordship kept in mind 3 when it has been brought to the knowledge of that whether it's a materials of railway or not. Now, PW6 Gopal Chandra Bora has intercepted the truck which came out the godown of Deepak Gupta, which contained the rail screws. He deposed honestly that inside the truck, accused Deepak Gupta and 10 other laborers were present. In the cross.
What honestly? Is there anything dishonestly before the court? Everybody says honestly. True or false, it is a different thing.
Different thing, definitely, madam.
This kind of word should not be recorded in a judgment.
Yes.
Honestly, because it will give comparative. PW6 says honestly, and PW3 only says. So his evidence is bit lower than
Exactly.
in standard. Anyway.
Anyway, in cross-examination, the defense totally failed to bring out the fact that the accused was not found with the materials. Some wayward questions were asked by the defense which failed to invoke the innocence of the accused. In this case, PW10 Dipen Kolita was posted at Nahakotia police station. When PW6 handed over the railway materials to the accused person at the police station, he had duly recognized the accused Deepak Gupta in the so-and-so and stated that he was present along with the truck. In cross-examination, the defense again failed to prove.
By the time this RPF man went to the PO to extract the railway materials, these persons were already arrested.
Arrested. They are in the police station. They were 4. Well, that's why the dates 4-2,
right,
5-2, 6-2. Initially, that is why I just lordship give the dates. These are the 3 dates, Malak. 5, they are in judicial custody. When it has been seized and inspected, they were not there.
But anyhow, the FIR of the Naharkotia is available somewhere.
My lord?
FIR of Naharkotia police station is available.
No, no. In fact, I tried to.
It is not here.
I tried to in an,
And there is no
about
material about the GR case also, nothing else.
Well, I have checked the records also regarding that FIR, whether I will get it or not. I didn't find it.
Okay.
I don't know whether Mr.
No, it is not there.
Record.
No, it is not there.
Record. Now, PW10, the Pen Colita was posted at Nahakote police station. When PW6 handed over the railway materials, the accused person in cross-examination, the defense has again failed to prove that the accused was not found with the railway materials. The defense put some questions relating to the number of RPF personnel present during the seizure of the size of the screw, but failed to bring out the perspective that the screws found from the possession of the accused did not belong to the railways. Kindly see that what is said, none of relation so and so. Failed to prove so and so. PW13. The Girish Gogoi is an inquiry officer in this case. He was also present with PW when rail screws were separated and seized at Nahakotia police station. He stated that 13 accused were arrested by the police. Among them, Deepak Gupta also figured. He stated that during her course of inquiry, he had recorded the statement of the accused person at Dibrugarh jail in presence of jailer. This is there at the jailers there at, and during the statement, whether it is a threat or not, I don't know. There, the word has been.
Which one?
In presence of assistant jailers, there it. Or threat, I don't know what it has been. And during the statement, accused person has pleaded their guilt in this case. The finding of the inquiry were to show no anomalies and report submitted by is very much believable. In cross-examination, the defense again failed to point out any kind of discrepancy in the finding of the inquiry officers. The prosecution in the case succeeded in proving the accused Deepak Gupta was an unlawful possession of the rail screws. The prosecution as initiated by the RPF in the case against the accused person is the result of the cooperation being made by the oil security staff and Nahakotia police, and as such, the possibility of any kind of prejudice against the accused is ruled out. The confession of the accused Deepak Gupta as exhibited by the prosecution exhibit is made all fairness. Now, whether it is a fairness or not, I don't know, my lord. The word is.
Fairness, honestly, all this.
The reason for justifying the fairness is solely because he has explained that what fairness is. The reason for justifying the fairness is solely because the statement was recorded while the accused is in judicial custody, and the statement was made in presence of PW 12. So that is why it is. He found that it is a fairness, my lord. The Sampakali Bordole, who was the assistant jailer of the Dibrugarh when statement was recorded, PW 12, in all her sincerity, deposed that she heard accused Deepak Gupta admitting that the purchase of the material from the unknown person. The statement so recorded by enquiry officers of the RPF cannot be excluded or discarded from the evidence of, because RPF is not deemed to be a police officer within the meaning of Section 25 of the Indian Evidence Act. And so the statement recorded by the RPF officer is an equation of confession. So it take it as a confession, and what it says that he admit now the exhibit 18 says about, well, what is this? The 18, he said that he did not stole any other, some this ferrywala has come and he purchased this from the ferrywalas. So that is his statement. Now, question before your lordship is this, here's what he said, whether it is belong to the railway or not. That is the main issue, my lord.
Mainly first to the evidentiary value of the statements. Exhibit 18.
18, yes, madam. That is, so the evidentiary value is.
Because the court has treated it as a confession.
Yes, confession, madam.
And 25.
25.
Not a police officer.
Police officer.
RPF.
RPF, madam.
But it was taken in presence of one jailer.
Jailer.
And it was inside jail.
Inside the jail.
And he was in, this
Judicial
man does not have any power to arrest.
My lord, they do not have.
But police has arrested him.
My lord.
In connection with.
Case in Hakote PS case number.
There also oil stuff is there.
My lord.
Oil stuff was there.
They are, my lord.
So railway property and oil property are different.
Two different, my lord.
Railway property are to be investigated under this act.
This act.
And oil security under IPC.
IPC 379.
So he was an accused. He was in custody.
Custody. And the statement which has been given.
No magistrate.
No magistrate. No magistrate. No magistrate. And
it is not 164.
No.
Yes, it cannot be 164.
No 164. Now it will come, it is, you have to say it is an admission.
My lord, admission.
24.
24.
Section 24. But that if the jailer is present, he is inside the jail, another person, they wear police dress?
Yes, they are in the police dress.
Railway police?
Yes.
They wear police uniform?
Yes, uniform, RPF uniform.
Then where is the coercion and all, that removal of the threat, perception of threat? No,
There is not there.
That is a guidelines has been given that whatever it is, whether it is a 164 statement or any statement where you have to caution that had be used so and so.
These are the state. Okay, we'll come to the acts later on.
Next,
okay, let us see.
Made before the fact that the screw seized by the RPF belong to the railway is undisputed because PW8 Shri Uddhav Bora, a very important miller, who examined the rail screw, has duly deposed the rail screws examined were exclusive used by the railways and seized materials were the serviceable condition.
Okay, it is not, say, for example, let us assume for a moment,
my lord,
these are railway property. Okay, mark for there. But question is about stealing.
There's another aspect also, my lord. See, when there's a railway property, my lord, always they have a mark. My lord, if this television belongs to Sony and these things, they have a mark of these things. Now the question arises that whether this, so that can be used, that cannot be used by railway also, or screw can be used by other person also for different purpose also. Now question is this, whether Well, it is the case, the prosecution has to prove that, yes, these are the railway screw. And because there's a vital contradictions, he has been examined.
No, Mr. Bora. First, we have to see because trial court judgment
My lord,
affirmed by the
appellate court.
we are in revision.
Revision. My lord,
And we have to see the striking,
my lord,
which strikes.
my lord, that is why I wait.
These contradictions, all these.
Because
I think
that
this
was
is-
that was totally escaped by.
Let us leave the matter of appreciation of the evidence to the two appellate courts, concurrent finding.
Concurrent finding.
You strike at the root.
Yes, root is what? That is number one. Root is this. Number one.
This
the confession.
PW3 and PW8
My lord.
contradiction, we are not going to compare.
No, because that was not been discussed at all. Because at first sight, kindly see, you have taken it to my custody by one, my lord, PW1. It was kept for about 2-3 months. Then he has come that on that day, when this screw has been taken by them, claiming that these are the railway materials, there was no mark of Indian Railway mark.
Okay, we'll read it
This is
further.
very, very important
Trial
thing.
court judgment, from we can find out that on what point the trial court returned a verdict of guilt.
My lord.
Right.
We
have to decide about this particular aspect. Section 25,
Yes,
Concession, Railway Act, Exhibit 18. That part we can.
Yes,
definitely.
my lord, why I'm telling you, apart from that also, your lordship has to see that where there is any, my lord, information regarding stolen things, my lord. Anywhere, Bongaigaon, Dhuburi, whatever it may be, Tinsukia, whatever, where from this has come. It will not come from the heaven, my lord.
Okay.
It will-
Right. And in fact, during cross-examination,
my lord, defense adduced, in fact, during the cross-examination, the defense digs his own grave, asking the rail screws board that IR marks to which the PW answered that rail screws has marking of IR, my lord. Now the trial court says, I have digged my own these things. It's a very pertinent question, my lord. Had it been not asked, my lord, this will not come. PW say, no, but I know he has committed wrong. He has committed wrong. But in fact, my lord, if you see your lordship, can you see? It's a very pertinent question has been asked. The reason being that PW3 at in his first stage, it find there is no mark, and he found the mark. So that's what I want to say, my lord. The defense
why the defense? Let us
the
see.
defense adduced the evidence of DW1 and that
Now,
defense.
let us read so that
my lord,
I can
defense,
have
sir, adduced the defense of DW1, Sri Mukul Das, to show that the accused did not deal with any iron scrap business, but the deposition given by the witness itself is shaky, as the time he cited the ignorance. If the accused has any iron business at that time, stated the accused had no iron business at all. The witness tried to show the accused was arrested when all of them were in a gathering enjoying the warmth of the fire, but flattered to say that exact date of his being arrested. The defense wanted to take a opportunity plea of alibi, but failed to prove the same in totality, as such the deposition of the defense witness failed to revoke the innocence of the accused. So far the defense is got nothing, my lord. That cannot be taken into the consideration. Reason being is that there is no plea and no suggestion to this effect also, my lord. So far defense is concerned, I totally, my lord, left this. This will not help me, my lord. So far defense is concerned. And rightly they have pointed out, my lord, line of trial court. It is also noticeable aspect that the version of DWD and the response to the accused during the examination under 313 of the Criminal Procedure Code are totally different, as accused stated that he was called from his home and arrested in this case. The defense itself failed to link up his own case of innocence in the instance offense. The evidence rendered by the prosecution in the case clearly showed that the accused Deepak Gupta was in unlawful possession of the railway materials. Not only that the very unlawful possession also casts reasonable doubt that the accused has stolen the railway materials, it is principle endowed in the criminal jurisprudence that once the prosecution prove its case through causal evidence, the burden is shifted upon the defense to show his innocence, and very factor of the innocence could not be proved by the defense in the instant offense in the case of the accused. On the very basis of the discussion of the fact law as mentioned above, it is transparent the prosecution in the instant case has traveled beyond all reasonable doubt, and accordingly accused Deepak Gupta is convicted in the instant case. The privilege of enumerated under section 3 and 4 of the Provision of Offences Act are not considerable against the accused, as he has committed the offence knowingly, as the nature of the case clearly suggests that the rail screws are recovered and concealed with other materials in the truck. I have heard Deepak Gupta on the point of sentence. He stated that he has a burden of his family and the case is dealt leniently. The circumstances of the case does not prompt me to deal the accused leniently in any matter. Considering the all aspect, Deepak Gupta is sentenced to undergo simple removal for 6 months, and the period already undergone by the accused be set off under section 428 of the Criminal Procedure Code. The seized railway scores are handed back to the concerned railway department for its use given under so and so. So trial court, my lord, in two aspects. One is regarding the admissibility confession that is exhibited. That is a confession which has been made, can be used against me as a witness, which is hit by Article 23 of Constitution of India.
Who is response number 3? Sorry, PW6.
3.
666.
6 is the officer, security officer of Oil India, my lord.
Oil India Security Officer.
My lord, Oil India. His name is Gopal Chandra Bora. My lord. Should I read his?
Yes.
I have, his name is Gopal Chandra Bora. I have together the date.
Apart from your reading?
I have forgotten the date, sorry. I have forgotten the date, but it was in the month of February 2006. I, along with my rifle party, were conducting a patrolling at Nahakotia near Nogao Tiniali. We intercepted a truck coming out of the godown of Deepak Gupta. I noticed some pipes belonging to the oil and other railway materials loaded in the truck. Inside the truck, Deepak Gupta and 2 loyal labor were present. I lodged an FIR at the Nahagotia police station and handed over the truck at the accused person. As the truck contained the railway materials, my statement was recorded by the RPF officer. I have not seen any accused person today in the court. Accused Deepak Gupta is absent with steps today. Exhibit so and so, Caesar memo, exhibit 3-1 is my signature. The cross at present, it is not possible for me to tell the names of the.
1 minute. Whether the screws were exhibited?
Yes.
No, they are not exhibited.
Yes.
No.
Exit police.
No, it's good. They are the specific of the whether there are. He said that no, my lord, what I didn't find, my lord.
Material exhibits?
What do you like?
No, that is why I want to know.
There's a seizure list.
Seizure list may be there.
There.
Otherwise, this number at least are to be.
I do not find while I go through the records.
The list of exhibits somewhere?
Your lordship may
List of
kindly see that
exhibits.
exhibits, list of exhibits on the trial court, my lord. Exhibit one is the first complaint. Then
We don't know where is your exhibit. 1 minute. 1 minute, 1 minute.
Yet na baba. Amar huh? Exhibit yet na kana question.
See your list. Is my significant. Exhibit 2, exhibit 8. The statement. Segmenting statement of for on. Exhibit 16 statement of alarm. 15, 14, 13, 12, 11, 10, 9, 8, 7, 6, 1 minute. Do you have any knowledge about exhibit A? 1?
Yes, my lord, exhibit one is the
No, be sure.
Complaint section?
is the first complaint, my lord.
Complaint.
Is the first complaint, my lord. Exhibit one, my lord.
No, there is prosecution report, right?
Here it is there. There is.
There is a complaint and a report, my lord. There's a complaint by Biseswar Musahari, my lord, to the inspector of RPF Muriani
1 minute.
and F Railway, my lord.
For exhibit. Four, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18.
No. There is no material exhibits also. It has been no written here. I have checked the
Judgment.
No, not about judgment. I have checked the trial records.
But
material object को पोआ ना
judgment में reflect होगा लेकिन.
नहीं हुआ. But there is a
From 14 to 18, exhibit, except 5. All are statements of accused persons.
yes.
Exhibit 18 is in
That's
here.
Expired.
But 4 to 18, all are statements.
Yes.
Except 5. I don't know what is 5.
5,
Exhibit 20 is prosecution report. Right.
Yes.
The 20 is the prosecution report, yes.
Let me find out what is exhibit 5.
Not 5 to 9, you say.
Mr. Bora and Mr. Vishwas, neither of your associate, I think, is a practice court lawyer, trial court lawyer.
Yes, I was in the trial.
No, I am not asking both of you, your associates.
Oh.
I don't think they are trial court lawyer. Mr. Bora and Mr.
It is
Yes.
also not reflected in the judgment, my lord.
No, the 2 and 3 are Caesar memo and Caesar list.
2 I have found now.
Caesar, that is 3 is a Caesar memo. 5 is a expert certificate. Sir. 5 is a expert certificate.
Exhibit 1 complaint. Exhibit 2 seizure.
Caesar, sir, Caesar, my lord.
Seizure.
Caesar. Exhibit 3 is a.
Who has said about who has exhibited 3?
The exhibitor 3, SRM Tinsukia. That is PW.
Where from you are seeing?
I have a photocopy before. Photo. 1 is a seizure list.
1 complaint, 2 is seizure list. That
Seizure
I
list.
have found. Now, what is 3?
3 is my lord, so far my photocopy is concerned.
Photocopy, who has exhibited? I am looking at the original one.
Yes, my lord. That is
Exhibit 3, seizure.
Gopal Chandra Bora. Gopal Chandra Bora. PW6, my lord. Gopal Bora.
PW6.
6.
1 minute. And somebody has exhibited seizure memo. Seizure memo. PW2. This is PW2. Okay. PW3, also exhibit 3. Okay, exhibit 4. What is exhibit 5?
5 is my lord. Expert survey, that is a Madhav Bora. Uddhav Bora.
PW?
PW8.
Okay. 1 minute, 1 minute. PW5, exhibit 5, expert certificate. Right?
Yes, yes. And
By PW, exhibited by PW8.
8.
Okay. What is exhibit 19?
No, Lordship has missed one, my lord. That is 4, exhibit 4.
It is statement.
No statement. So far my concern, exhibit 4 is the my lord Porisha Patra. That the dam, this thing, he was exhibited at PWD.
PW?
PW. The hell is
Who?
PW7.
PW7. To say PW7.
PW7 is regarding.
মই দিয়া প্ৰমাণ পত্ৰ পুলিচ আহিছিল সেইদিনা ইনফৰ্মেশ্যন বিচাৰ মই প্ৰমাণ পত্ৰ দিছিলো হি ইজ গভৰ্ণমেণ্ট গাঁওবুঢ়া
Yes, madam. Regarding the dam, the land of the dam.
ব্যৱহাৰ কৰে মই exhibit 4
5 is the expert. From 6 onwards, the statements.
PW7. Okay. What is exhibit 19?
Yes, 19, your lordship will. 17, 16, the 14 statement, 19. Peaceful as any game, no, more
13, 14, 15, 16,
18,
17, 18, 18.
18. Up to 18 I have.
18.
19 I do.
18. 17.
18 to confession statement.
18 is the sheet anchor of a prosecution case. 10, 20.
19, I don't know, the 18 is a statement of confessional statement. 18.
18 is confessional statement. Then 20 is
20 is a complaint.
prosecution
report.
Where is 19?
19, in fact, I do not have also 19.
19 is not available. Okay, let me flip through. Porisha Patra I have seen.
17.
Exhibit 4. Porisha Patra, exhibit 4.
1, 2, 3, 4, 5, then 6 statement to 18. The
Expert
19 I-
certificate 5, I have seen. Statement 6, 7, 8, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Okay, 20 is missing. 20 is missing.
20 I have, Milord.
Oh, no, 19. I'm sorry. I'm sorry, 19. 19 is missing.
19 I do not have also 19.
19 is not there.
I have also the photocopy. I don't.
19 perhaps is missing. Inspector, report. So who has exhibited? Whether seizure list is enough?
My lord, your lordship rightly pointed out it that that is not enough. But if your lordship
My
believes
lord,
the confessional
has to
statement,
be, it's the prosecution to prove that these are the screws.
no,
In
that
a
has
case of a trap case, my lord,
Right.
unless the notes has been exhibited and it is not
For
been-
NDPS, the contraband. Now NDPS has devised another procedure. NDPS
My
Act
lord.
that you can get it certified
My lord.
certified.
from the magistrate.
Magistrate, yes, sir.
And thereafter that certification from the magistrate is enough.
Enough.
That is to be treated as primary evidence.
Primary evidence.
Now where is that now?
But in whether in railway RPF Act it is required.
So, it is
It's
governed
the
by the CRPC.
CRPC.
I tried to go through it. Please have a go through all the statements of the witnesses, whether they have exhibited
No,
material
Milord.
exhibit.
Except seizure list, my lord, I have minor.
Have a confirmation.
Milord,
Yes,
definitely,
that
I have.
then everything goes. Why we should
My lord, I have.
wonder about?
My lord, I have personally today, my lord.
Oh, my
gone for the- yes, for your lordship's satisfaction, my lord. I just one, my lord. I just want to, because, my lord,
Because
see what has happened, my lord.
Neither
Suppose
the-
a trap case, my lord.
neither
A
no-
money has been kept in my pocket and that has been a trap before after the pre-trap memorandum, it has been recovered from my pocket. There, the 10,500 notes. Right, exactly the screw, the 2,247 screw. Unless and until that is a material object. Seizure is not a material object. Now material object, you have to show that these are the material object.
One thing, Mr. Biswas, it can happen because it is a seized property. That can be released under 451.
Yes.
Right. Whether it was a thing. Then there has to be this seizure memo or Panchnama.
Panchnama.
Right. Seizure is not Panchnama.
Panchnama, exactly.
Not Panchnama. Panchnama here where the accused drawn up, Panchnama is drawn up, then thereafter the seized material can be, interim custody can be done, released for say vehicle, other materials. Now railway screw is required to be used in broad gauge. So it cannot be kept for production as an exhibit.
It was given Jimma to railway.
Find out, sir. Material exhibit, I don't think it has been made.
And that is why, Milord, in the last lines of the orders, it said, if your lordship kindly see the judgment,
please.
That is this, the lordship kindly see the judgment, Manat.
It is there.
You kindly see the consider all the seized railway screw are handed back.
But whether it is seized.
Where no, my lord. So that is what I have want to say, my lord. So it has been written here, my lord. The seized. It's been written. The seized railway screws are handed back to the confirm. The question, your lordship, yes, what you have said, 451, that can be so and so, so and so.
It can happen.
Happen, my lord.
That
But here, on the face of it, my lord, it found that it's lying in the court.
It would not lie in the court.
But it was, my lord, that is what is, it is said to be the Malkhana, my lord. See the article, in the Malkhana. But if your lordship kindly see, while even that is why it has been written as a debt or normal procedure, but the trial court has written like that, whatever earlier has been returned back, destroy it. Be that also, my lord. And I'll just, my lord, what I have, my lord, want to say about PW3, I will come, these are the factors, my lord. Number one is, you cannot be a witness to your own, my lord, this. Second is, just PW3, what is, PW3 is a very important thing, my lord. That was totally, my lord, has totally escaped, my lord, the trial court, both the court, my lord. He was the first person, my lord. Thus I do the two line, then I so and Girish Gogoi came to Naharkatia. I along with them, and again went to the Naharkatia police station. Thereafter, we separated. We separated the rail screw from the track and found 2247. He is the person, PW3, was the first handling of the screw. We kept aside of the so. In the cross, what it says, 3 says,
Memorandum. Fraction of 3. Four two. Prosecution report. লাহে লাহে ল'ব আনিব দিয়ক এনেকে আহিলে নহ'ব ৰাস্তা বেয়া হ'ব এনেকে It could happen that magistrate realized at the time of writing judgment, it was not exhibited.
Yes.
He added the last statement.
it may be,
It could happen.
It may have,
The learned session judge also ignored it. How he should have pointed out.
because what I found, there's a specific question has been asked whether the screw has been today found in the court or not. They said no. There's a specific question has been asked during the cross-examination regarding about the screw.
To whom?
To one screw that I have, I forgot I have, that is why I have going through below what I found.
In the absence of identification, say exhibiting it materially, then who can say?
Exactly. Very true.
And where the seizure list?
Only on the basis of report will not do.
Where is the seizure list?
No.
Check if the seizure list exhibit 1 and 2.
What was mentioned here?
Seizure list, well,
1 and 2, you said?
exhibit 1 and
2 and 3, 2 and 3.
2 and 3. F1. Date of seizure, one seizure, that is exhibit 2 is one date of seizure, 6/2 so and so at about even. Place of seizure, Nahakote so and so. From whom seized from Sri Dipen Kolita, SI, PS, Nahakote district so and so, so and so, so and so, so and so. Nature of article seized, rail screw, PG, 224 cell numbers, signature of the witnesses, Gideon Gogo, signature of impression of the
Nothing.
accused.
2 so and so.
Man.
Seizure list, this is 1. Exhibit?
Exhibit 2?
3. Exhibit
Or 3.
exhibit 3.
3 is a seizure memo. Date and time of seizure, 4/2 so and so at 4/2/06. That is by the seizure of the police.
Right.
Name of the designation of the officers, DK Kolita, Nahakotia PS. Place from where seized, Nahakotia so and so. Circumstances of the seized and from whom seized with address. Iron cut like with track number so and so, handed over by Security Officer Sri Gopal Chandra Bora of Duliajan PS. Yes, Nahakotia PS, case number 106 under section 379(4)11 IPC. Signature of the particular seized witnesses. Havildar Ratnesaka of the All India branch PS Duliajan. Havildar Lasit Borua, Oil India so and so of PS so and so. Details description of the seized articles 4x10 of 100 numbers of cut pieces, 2.5 inches into 8 inch of 50 meters cast, 50 numbers cut pieces.
This is exhibit 3.
Exhibit 3.
Handed over by Gopal Bora.
Gopal Bora, that is
to the
PW6.
Enquiry officer.
No, PW6, that is Gopal Chandra Bora, is all security, PW6.
No. Gopal Chandra Bora, I know. Who has seized it?
This is seized by DK Kolita, Nahakotia Police. SI.
Naharkotia?
That was seized in connection
That is in the
connection
case.
Yes,
And then exhibit 2, from where this railway enquiry officer he has seized.
Yes, that is
from whom?
From whom? 6/2 तो की है Girish Gogo, no, signature of the, equal it on how, the signature of the officer. The signature I could not find this.
The person designated, I think he could be the IO or OC of Naharkotia only.
Definitely, man. Because 4 arrested.
There is no involvement.
There's an information from the Naharkotia RPF.
There is no involvement of magistrate.
Yes.
No. In either of the seizure list.
No.
Initially, it was seized by the police.
Thereafter, the RPF.
We have taken back
from the IO. Naharkotia
IO.
So, this exhibit 2 and 3 seizure list, which are prepared by the
police
and RPF. And there is no Panchnama.
Yes, it is not.
To act as a substitute to the seized screws. We don't know what is 19. Other than 19, we have checked everything. Then material exhibits are required. Because that is the subject matter of the entire prosecution.
It is not in the data company.
That is a subject. Yes, some other case is a different thing. Murder, some lathi. Yes, direct evidence. Eyewitness, lathi dispensed with. Non-production may not be fatal for.
But still it is required.
it is required, always desirable.
Yes.
But here, the subject matter of entire prosecution is the screw.
Screws 2247.
Where is that? Vanished. That is why I am giving this opportunity, so that if that task is easier, my task is easier.
Definitely, Vinay. Now, earlier what has happened, we have gone to Tufan Singh cases regarding.
Because it was never, it was not there that these were taken from position from the accused.
Yes, it was taken position from the police. Police, and particularly why I have said to the PW8 is concerned, he's an expert. What he found that, if you kindly see, that's just one line, Malak. Kindly see, on 1616.
Everything is with Mr. Biswas.
Malak, only things are there. The expert, when he was being called, it has been in the month of February, 4th February, 6th they have taken away. Then he has been called on 6th, that is in the month of June. One Suk so and so, I was called by the RPF, and he has gone on 8/6. That means after 4 months, he examined the screws. And my lord, and PW3 is the initial witness to the screws. He and PW1 has segregated the screws from the pipes. These are the screws belong to the railway. And he said, well, the first instance, what he says, the cross-examination on 4/2/2001, Gopal Bora of Oil Security came and showed me the rail screw for confirmation if the rail screw belonged to the railway or not. I, along with PW1, gave the confirmation that the rail screw belonged to the railways. The railway screws shown to me had no IR marks.
He has been convicted penalty for theft. And theft had the same meaning as given in IPC. An unlawful possession.
Yes.
Right? Possession, Naharkotia police has taken possession from oil security officer.
Exactly.
Right? Then
RPF has taken
Naharkotia
from
police has taken, handed over the position to the RPF.
RPF.
Possession was not taken from the accused.
No.
No, that is unlawful possession is the charge. Second is theft. For theft also, the subject matter of, suppose a person is charged with the offense of, say, committing theft of a gold chain. Either a panchnama or the gold chain is to be there. Either a gold chain.
There has to be either GD entry also. If there's a GD entry there to that effect or punch number, whatever it may be, there has to be there, my lord. That now the question whether it is that is the thing which not be an appreciation by both the appellate court as well as the trial court regarding the contradictions regarding whether the materials belong to railway or not. First of all, the prosecution has established this is the railway materials. The first instance, the PW3 and PW went there and segregated the railway articles. They said, and there's a specific question has been put to him that whether this is any marks of railway marks or not. No. He said that there is no railway mark, IR mark. And the expert found the IR mark there. Now, which one do we believe? He examined the screw after about 5 months. I don't know what screw has been shown and all. That's a different thing.
There has to be a malkhana, all these things.
Yes.
Have you gone through, Mr. Biswas?
Yes, my lord. The point raised by your lordship are really missing in the record. But now your lordship is to be confined by one thing and another also. But the confession made, we have been struggling all these days only on that point also. That before the police, where police officer was present inside the jail. And now regarding seizure also, it has been seized from the police, not from the accused. And moreover, my lord, Other things are that expert opinion we cannot rule out. Expert opinion we cannot rule out.
Expert opinion, my respectful submission, I give a reply. What he said, it can be used by railway and there's a mark. But if your lordship kindly see the evidence of PWD3, who are the initial person who identify it's a railway property, will not. He said there's no IR mark.
In both the court has relied on confession of the Gupta.
Confession, whether there's confession, my respectful sir Balakrishnan, that number 2 point, what your lordship has pointed out regarding to, my lord, no, you cannot be an accused of an offense, shall be, my lord, compelled to be a witness against himself. So I was in a jail in a day, they came with so and so, nothing of sort, nothing, and he has
There is
taken
a
us.
proposition when the best evidence is available.
Yes.
Then prosecution is required to exhibit and adduce the best evidence.
Must.
In the absence of best evidence, then an adverse inference is drawable. Now here the material exhibits are not produced. Anyway.
Yes, it is.
That, but in any other form, it can be produced. Even by way of Panchnama. That is not there.
That is also not there.
Not there. Seizure list. Seizure list does not establish possession of all these nuts and bolts
from
with the accused. With the accused. First seizure list is from oil security officer.
Yes.
By the IO.
By the IO.
And second seizure list from the IO to the RPF.
RPF.
So possession is not established. If the possession is not established, then we come to exhibit 18. We'll inquire into it. We'll try to find out what is exhibit probative value of exhibit 18.
So that is why, if your lordship kindly see, we have earlier cited the Balakrishnans also.
I have to go through it.
Balakrishnan Milan. Balakrishnan case, earlier we have regarding so far that the police officers are inadmissible because in that Tufan Sikh case, everything has been pointed out, but except the NDPS, it has not been there. And also, this Balakrishnan case has also been dealt with, but it was not overruled. My lordship has to see one thing. Stringent statute like NDPS, my lord, is very much stringent that of this Railway Protection Unlawful Properties Act, my lord. I do not understand that
Railway property,
well,
that has not been given that status like NDPS. This punishment itself shows.
So punishment
No,
is
you
very
cannot
whatever it may
equate,
be.
you cannot equate NDPS Act with this.
Yes.
Extend to 5 years or with fine.
Or with fine. Now what?
And 10 to 20 years. You don't compare
No, but
Railway Property Act with NDPS.
but if you convince,
Not comparable. Absolutely not comparable.
so the laws are not.
The law is
The
stricter.
law is not equal
punishment,
then.
the stricter is the compliance for the procedure.
Well, so my third leg of argument is regarding Article 23, the admissibility and my lord, this
20 within bracket 03.
yeah within bracket 2003, my lord.
Otherwise, Article 23.
Not 23, Article 20 within bracket 3, my lord. So that is my submission. So Balakrishnan case is absolutely clear. So for 23 is concerned, just one line, I'll just one line on. Nothing, I'll just yeah, that's it. That is just paragraph 64 onwards. Clause 3 of the article, clause 3 of Article 20 Constitution read thus: no person accused of an offence shall be compelled to be a witness against himself. That is, an analysis of the clause shown three things. Three things. Number one, firstly, it is protection is available to a person accused of any offense. Here, P79, I'm an accused of an
No, we'll check one thing that that is one Article 20, but another issue that condition precedent for recording the statement is issuance of a notice.
My lord.
Under Section 9,
My lord.
he has to issue a summon.
Summon.
That is a condition precedent.
My lord.
Then that man will know that this man has come
and to
for
keep
inquiry, and I have no fear of arrest.
Here, no notice has been sent. They have straightway gone to the so-and-so. Being a police officer, my lord, he gone with an
That
uniform.
cannot be.
So that cannot be. So, therefore, in my respectful submission, my lord, the 20, the exhibit, 18, is not at all admissible, my lord, by law.
My lord,
And in section laid down in 9 also.
Yes.
when Balakrishna Madhavan said that police officer who is test officer of RPF making inquiry under section 8(1) of the Real Property Unlawful Possession Act 1966, 29 of 1966, held not a police officer.
Right.
Within the meaning of the section 25 of the Evidence Act, section 162 of the code, position of the customs or excise officer also not different in this regard.
Difficult, sir,
Hence, the
difficult.
confessional incrimination recorded by the officer under section 9 of the 66 Act, his course of inquiry cannot be excluded from the evidence.
That is why I've been asking you for on Balakrishna. That is very difficult. We'll find out. That is why I said whether materially exhibited or not. The document, Panchnama, all these questions I have been asking you for that purpose only. Balakrishna is very difficult to deal with. We have to make many extra effort.
Kindly see what your lordship has said regarding theft. No Panchnama.
That is why because of Balakrishna, I have been, Mr. Bora.
Yes, my lord.
I have been hearing you with patience. Otherwise, it could have been easy for me. But because of Balakrishna, I have been hearing you. And because of this Tufan Singh. Tufan Singh also did not touch it.
Yes, yes. No. Tufan Singh is not touching. Balakrishna doesn't touch it.
Balakrishna stands.
Yes, my lord.
And Balakrishna stands when an inquiry officer doing inquiry under Railway Protection Act, he is not a police officer.
Right.
That also stands.
That also stands.
In that context, I have to see Exhibit 18.
My lord, no, Exhibit 18 is the confessional statement. And so far the 19 is concerned, I didn't find. That is why what has happened, my lord, I was searching.
Other statements exhibited of co-accused in their absence and in view of Section 30 cannot be used.
My lord.
Yes.
Section 30 of the Evidence Act, and because in their absence, that cannot be used against a co-accused like the petitioner here. Those are discarded. Then two seizure lists. I have been working on it. Then Exhibit 1 and Exhibit 20, they are prosecution complaint and one complaint. So what remains? The material exhibit. Material exhibit is not there. So that is why.
That is
how to
main hurdle for me. The material exhibit is not there.
That's all. That is why I have been listing the exhibits. This one only for the reason what probative value each one of the exhibit has. We find that from 6 to 18, 18 leave aside, 6 to 17, they are statements of co-accused. And that cannot be used against the petitioner.
That goes.
More particular in their absence.
In their absence.
Right. They can be used for them in their trial. That goes. Two seizure lists. That goes. No possession.
No possession.
Complaint. That does not have any probative value. Prosecution report does not have any this value. Then Exhibit 4, Gamura certificate.
Nothing.
Nothing.
Even then, my friend is very worried.
Huh?
Very worried.
No, worried means, my lord, initially what I, my lord, going through, my lord,
Balakrishna is very difficult, Mr. Vishwas.
Yes.
Heard Mr. P. Varal and Senior Counsel listed by Ms. K. Bhattacharya and Mr. S.C. Biswas, learned Standing Counsel.
No, Special
Retainer
Counsel.
Counsel. Special
Counsel
Counsel.
NF Railway.
NF Railway. With Miss
For the respondents. Most of the arguments are hard, judgment is reserved. I
Was given a passionate hearing,
Passionate.
not for the one day. I feel wonder, earlier 3 hours you have given the dictation. Now again you have heard it. I thought that you will not take up the matter. And earlier 2 occasions also your lordship heard it matter.
No, I have read Balkrishna and I
Yes.
have realized, I have gone through Tufan Singh also, I have realized.
Yeah, Tufan Singh, my lord, I have got twice, my lord. After that, what has happened, my lord, honestly, it goes from the mind, it comes ultimately to NDPS. In nutshell, my lord, it comes from nothing. So what are the other paragraph, what are the stated? I got confused.
I have to learn, but because I have
also learned many things.
I have dealt with railway property for the first time.
No, here also Guwahati High Court, no cases is there. I had checked everything. But whether the railway under the railway protection, whether they are police officer under so and so or not, there is nothing. So far the Guwahati High Court is concerned, I have checked. Even I use AI also regarding.
We'll find out.
Much obliged, Mullah.